Oh, yeah, oh, yeah, oh, yeah. All person cited for the honor, the United States Court of Appeals for the District of Columbia or non-here in either God save the United States in this honor. Not to take the
Morning, Council. Mr. Cohn, please proceed when you're ready.
Thank you, Judge. Good morning. May it please the court. The issue in this case is whether there was sufficient allegations of probable cause to support the issuance of a search warrant for the search of the home of Mr. Payne. The search warrant was, and the parties agree on this, defective in that it failed to cite the correct statute. I mention that because the Superior Court judge who eventually signed the search warrant repeated that error in his authorization of the search, strongly suggesting that he had not taken the trouble to read the statute for which a search was being sought. Beyond that, the reaction of the Superior Court judge upon reading that Mr. Payne had heard gunshots outside his home, had had his cousin run into the home wounded, and had gone outside his home with a firearm to see whether the threat was still going on. The reaction of the Superior Court judge to the police officer who submitted this affidavit should have been, you've done a textbook job of identifying a poor Second Amendment protected conduct. Conduct is happening in the home, and he's acting in self-defense. Why do you want me to authorize you to search every part of this person's home for, as you put it, firearms, ammunition, and so forth? That doesn't seem.
Let me ask you this. If this had been raised at trial as a defense, the government would have had to disprove self-defense beyond a reasonable doubt, right? Because self-defense could have been an available defense to the unlawful possession allegation, right? No self-defense instruction was requested at trial, where the burden was to prove beyond a reasonable doubt. The burden to get a search warrant is probable cause, which is multiple magnitudes less. So how is it that in a case where defense counsel didn't even request a self-defense instruction at trial, it was error for the judge to sign a search warrant and find no probable cause?
The trial judge, now we've got lots of evidence coming in addition, to be very concrete, evidence that's not in the affidavit submitted. I'm not sure I'm pointing in the right direction to the Superior Court judge. So we're talking about two very different inquiries. One is looking at the affidavit. Has this affidavit laid out anything other than protected conduct under the Second Amendment? Whereas at trial, the defendant's counsel has to make a strategic call. Okay, given all the evidence against my client, including evidence of that's not included in the affidavit, for example, what happened, say, before the shooting? Is this really going to be a viable claim? So those are two very, very different inquiries at two very different stages. One is happening in the Superior Court across the street, and the other is happening at trial in this courtroom.
Is it your position that there was not probable cause for the offense listed in the affidavit, which was DC Code 22-4503.
That's correct, Judge. Yes. And I think the government is conceding that.
And that is because
Because that offense is the offense of being a felon or a prohibited person in possession of a firearm. And there's nothing in the affidavit that suggests that Mr. Payne was a prohibited person. And in fact, at trial and now still today, he was not a prohibited person.
so there's lots of case law about kind of typos and technical defects in warrants. The warrant itself says that the offense at issue was carrying a pistol without a license. And the DC code provision was one digit off. Why shouldn't we essentially presume that the judge signing the warrant obviously believed that the offense at issue was carrying a pistol without a license, not being a prohibited person in possession?
One answer to that question is the very first words as I start to speak. In his authorization, the Superior Court judge repeated the incorrect 4503 statute. So it becomes, and the significance of that, Judge. I mean, candidly, I've made typographical errors. I understand the case law that you just referenced, but here we're looking at whether a Superior Court judge actually examined the way the Constitution wants, it requires a judge to do.
But the authorization repeated essentially the same typo.
That's right.
But in parentheses said carrying a pistol without a license.
Okay. So let's move off the typo, although the typo has some significance. The question then becomes carrying a pistol. And there I would come back to the Second Amendment. The conduct that's laid out is poor constitutionally protected conduct. And it's important to note, it's not just today or tomorrow. In 2022, when these events were happening, this court had decided the Wren case. And the Wren case said that both in a home and outside a home, carrying a pistol for self-defense is poor Second Amendment protected conduct. Not me, it's this court saying that. So when the police...
By 2022, hadn't the DC Court of Appeals disagreed with Wren and said that this statute is constitutional?
No, I'm talking about the constitutionality, Judge, and it's important to understand, I'm not talking here about the constitutionality of a statute. I'm talking about the scope of the Second Amendment. And I want to repeat what I said at the very beginning. Someone reading that affidavit would have said, this is an outstanding job of describing core protected Second Amendment conduct. It's not a question, which, by the Judge, as you may know, is pending in the DC Court of Appeals across the street. It was argued late last year of the validity of the license requirement. That's actually under scrutiny right now. But whether DC can even require a license for us to have pistols in our home. But that's not the challenge here. The challenge here is to look at the affidavit and to say, this affidavit lays out a great example of protected Second Amendment conduct. I'm not issuing a search warrant for this.
I don't understand the difference between unconstitutionality and constitutionally protected conduct. And wouldn't the question just be whether the Constitution, the statute is constitutional as applied to that conduct?
I don't think it's an as applied case, Judge, because in a way, get back to Judge Wilkins's question. As applied challenges come up when you're challenging an indictment or a conviction or where you're trying to wipe out an entire crime. But that's not what my briefs are about and what this argument is about. The briefs here and the argument is when a reviewing judge under the Fourth Amendment is looking at the conduct described, the judge and the police who submitted it had to realize this is not a crime. This is protected conduct. And I don't
It
think
might be a crime. I mean, there is not mutually exclusive whether something is denominated as a crime by statute and whether it's constitutionally protected conduct. The way that comes into whether the way that intersects in a way that allows somebody to determine whether that in fact is constitutionally protected conduct is whether the statute can constitutionally prohibit it. If it can, then it's not constitutionally protected conduct. For those purposes, the statute can validate and predict it. And I guess all of this whole colloquy just illustrates that these questions can be quite nuanced and complicated. And we're talking about an approval of a warrant. At that stage, a judge who's looking at a warrant is supposed to do all this constitutional inquiry to try to figure out the conduct that's described in the affidavit, the statute, and let's just assume it's the right statute, as you rightly did. Let's assume that, and then we have a statute that covers it. And a judge that's thinking about a warrant is supposed to look at that and figure out at that stage, as opposed to later, somebody can raise a defense. But at that stage, in deciding whether to authorize, whether to issue a warrant, whether the statute can constitutionally be applied to the conduct that's described in the warrant affidavit, that seems like expecting quite a bit of a judge who's signing off on a warrant.
No, Judge, I not only do I not think it's expecting quite a bit, I think that's the reason the police should not have even submitted an affidavit. That's the significance of this court's decisions on the Constitution. They don't just affect judges and lawyers like me. They affect the entire country, all citizens.
And that's why you can raise a constitutional defense if the charges go forward. And maybe there's a civil suit you can bring under 1983 or something. But at this, I'm not. Do you have a decision where this has happened, where a warrant was where somebody in the posture that you're in got the fruits of a search invalidated on the theory that the warrant should have never issued because the conduct was, as you put it, constitutionally protected?
If there is such a case, it's probably in my brief, Judge, and I can't think of it offhand. But I think one helpful way of addressing your question is in the case that I was referring to of Judge Garcia, one that involves the constitutionality of this licensing scheme. One of the things the parties are going back and forth about, fully briefed at this point, is whether or not this licensing scheme imposes, and I don't want to use the word burden, and they have different words for burden on citizens, that infringes the Second Amendment. Mm-hmm. And if I am in my home, if a citizen is in his home and has shots gun outside, a family member runs in wounded, he takes a gun. By the way, it may not even be his own gun, and goes outside and scans to see if the threat is still going on. It is a burden on that person to then, oh, you did that? Well, guess what? We're going to do a search warrant of your entire home based on what you did. The fact that all these courts, including this court, has said that is core Second Amendment protected conduct. Sorry, we're going to repeat that and say, we are now searching your home because you told us.
The question that this is core Second Amendment protected conduct, I think, is a little more complicated than what making it out as. I mean, you have a right to self-defense to the threat of imminent bodily harm. There's a shot, and even in the affidavit, the detective says that when he spoke with Payne, Payne said he didn't witness the shooting. His cousin ran in, the car was gone down the street. So the imminent threat, I mean, you put yourself in danger going outside. Everyone who, it would be different if there were evidence in the warrant that there was someone still outside, or that there was shooting, or that the shooter might still be in the vicinity. But what's in the warrant is that the car sped by, shot at his cousin runs in, the car is gone. So why isn't that probable cause, at least probable cause, that going out with a gun at that point without a license is a crime? Because maybe if there were still a threat, an imminent threat, it might be self-defense. But where's the evidence of imminent threat in this warrant?
Judge, I'm glad you used the word threat, because the word threat is in the affidavit. And the police recounts that as soon as Mr. Payne realized there was no more threat, I don't have the exact words, he went back into the house. So he's responding to a perceived threat. And once he sees there's no threat, he goes back into the house. And so, yes, Judge, and then expanding a little on that.
He said there is no longer a threat and he goes back in.
Right.
That doesn't mean that there was a threat when he went out.
Well, there's another, an answer to that is there's no finding on that whatsoever, Judge. And I mean, it would be really odd for this time.
I mean, you want us to litigate this this warrant as if like we're at a trial or, you know, a detention hearing or something.
No, Judge, I mean,
That's not the way we look at warrants. It's
Right.
whether, you know, a neutral, detached magistrate kind of using their common sense can say there's probable cause that a crime was committed here. And what's the significance too of when Payne's interviewed, he says, oh, that's not a gun. I don't have a gun. That's consciousness of guilt, right?
He immediately followed, well, if we can deal with the threat thing and then that statement, I mean, my response to that, he immediately follows by that by saying, I want a lawyer. It's not, the statement was not admitted during trial. That's not the kind of statement that's going to suffice to show probable cause. But Judge.
A statement that that's not a gun when there's a photo and he matches a description of the person in the photo with the gun.
That doesn't change the Second Amendment analysis that he says that's not a gun, Judge. And to state, again, to stay with your description of a threat, I mean, I think the Second Amendment, candidly, is, as I've read the cases, is broader than you say. It's not saying, okay, the threat ended right here. So at this point, he's no longer protected by the Second Amendment. We're all human beings. When people get shot and run into our home wounded, our perception of the threat is going to be different based on different human beings. Some can be as the ones that the government describes in its brief. Just stay in the home, stay quiet, wait for the event to pass. There are others whom the Second Amendment protects, who take such threats with more emotion and human emotion and would go out to make sure that their family was safe.
Sure, my colleagues don't have additional questions for you this time. We'll give you a little time for rebuttal.
Thank you, Judge.
Thank you. Mr. Hansford.
Good morning, and may it please the court, Eric Hansford for the United States. The good faith doctrine quickly takes care of the Fourth Amendment issues in this case. And on those Fourth Amendment issues, I think it's worth starting where Judge Wilkins' questions left us, which is that this is not a self-defense scenario, at least not so clearly a self-defense scenario as to defeat probable cause. By the defendant's own account that's given in the affidavit, he is inside the safety of his home when he hears gunshots outside. His cousin then runs back inside. At that point, he is in his home safely. His cousin is in his home safely. There's no clear grounds for going outside in self-defense. Self-defense is a doctrine of necessity, a defense of necessity, and it is not something that can be invoked by running outside with a gun and trying to fire back. And at least it's not so clearly that sort of doctrine that it would defeat probable cause. And then we get an additional layer of deference through the good faith doctrine. There's also no defense of others. There's no defense of property claims here. And so for all those reasons, this was not the sort of scenario where potentially you would have a magistrate or a superior court judge denying a warrant based on
What
that.
would be that scenario? So if you have a situation in which the warrant affidavit itself is in the area of conduct that could be constitutionally protected in the sense that there couldn't be a statute that could apply to prohibit it.
So then, I mean, I think, so that what I was just talking about is kind of factual problems with, then I think there's a whole another set of potential legal problems, which is that we have a licensing regime in the District of Columbia that's been upheld by this court in Wren. Bruin, after this court, suggests that is constitutional as modified by Wren. The DC Court of Appeals has upheld that licensing regime even more broadly than Wren at the time. And there are no cases that the defense has cited that would suggest that a facially valid licensing regime under the Second Amendment must give way in scenarios of self-defense. Maybe that is the case, but a warrant affidavit is not the scenario for litigating that sort of claim. I think the Michigan v. DeFilippio case that we cite in the briefs, which is discussed in the Hine v. North Carolina case, that's that sort of scenario where the court says, even once there's a facially valid ordinance, the police are allowed to make arrests based on it, even if that ordinance is later struck down as unconstitutional. The fact that police made arrests based on that, that's supported by the Fourth Amendment, and the police don't have to second guess the constitutionality of statutes. So I think that's a separate legal problem.
And then what about the judge who issues the warrant?
Same scenario. I mean, there's no reason that a judge has to be second guessing the constitutionality of seemingly facially valid statutes, or at least there's no cases cited that would suggest that. And that's particularly the case when that statute, that specific statute, has been upheld both by this court and the DC Court of Appeals.
But there is a self-defense. The defense of self-defense is available to someone who doesn't have a license and carries a pistol
That's correct.
outside of their home.
That's correct. Under DC law.
It's used every day in Superior Court. I used to use it.
Yeah. That, yes.
So to the extent that this warrant can be read as there's a shooting, family member is shot, don't know where the shooters are, whether they're still in the area. One picks up a gun, even if they don't have a license, to go investigate whether there's still a threat. Why isn't that in the range of self-defense?
So one, I think whether that's in the range of self-defense at trial and for beyond a reasonable doubt is a very different question for whether it would defeat probable cause. But I think self-defense is a doctrine of necessity. What we say in the Robert Brown case from the DCCA that we cite in the briefs, you can't leave a safe haven and go out with your gun. That's not self-defense. When you are leaving a safe haven to try to fire back, that's not self-defense. And again, certainly not self-defense on the kind of deferential probable cause scenario. And I do think it's notable that the very competent counsel who tried this case below said, I'm not raising a self-defense claim in this case. And I do think that's informative in terms of whether it would so obviously defeat self-defense as to invalidate the warrant under the good faith doctrine.
Can I just ask as a legal matter, unless I don't want to.
Go ahead.
Just as a legal matter, if it's a defense at the warrant stage, is a judge who issues a warrant expected to treat with a potential defense? Or does the judge, I just don't know the answer to this.
Yeah,
Does
so
the judge just not even take into account defenses because just don't know whether the defense is going to be asserted or how it's going to might be, don't even know if there's going to be a trial, don't even know if the crime is committed. We're just talking about probable cause.
Right. So the briefing does not get into this issue, but I did kind of briefly look at it in preparing for argument. It seems like different courts take different positions. I think in the 11th Circuit and the 9th Circuit, an 11th Circuit site, it's an unpublished case, but it collects published cases. Rickerson v. Jeter, 2022 Westlaw 2136017, collecting a bunch of 11th Circuit cases, says we don't even need to worry about police officers. These are in the 1983 qualified immunity context, but saying police officers can execute an arrest warrant once they have probable cause as to the elements, and they don't need to worry about affirmative defenses at all. Then there's a contrary position taken by the 6th and 7th Circuits. The 7th Circuit case, Brunson v. Murray, 843 F. 3rd 698. They say police don't have to investigate affirmative defenses, but if there's a very clear affirmative defense, they can't ignore that. So I think that's kind of where the case is.
My understanding is that the latter is the majority position, and it's a position to me that makes the most sense. I mean, if you have a situation where the warrant says, a person is, attacked and being beaten and stabbed and by several, assailants. And then in the process of that, he pulls out a gun and shoots and kills one of the assailants. And that's what's in the warrant. I think there would be ample case law that there's no probable cause for carrying a pistol without a license or first-degree murder or any sort of homicide on those facts. The police don't have to investigate, but what they have points completely at a self-defense scenario, not at a crime.
So as I said, I haven't gone, I trust the court's kind of representations. I haven't gone deeply. I do read the 11th Circuit and 9th Circuit cases as potentially contrary to that. And this issue obviously isn't brief. I do think it's worth noting that this is a search warrant context as opposed to an arrest warrant context. And so I think if you have, for example, a homicide and potentially it appears to be self-defense, I think you would still expect the police to be executing search warrants as part of the homicide investigation. They wouldn't be cutting off the investigation because initially it appears to be self-defense. They'd still be investigating it. And then maybe you're not bringing charges and that maybe you're not bringing an arrest
There
warrant.
still has to be probable cause that a crime was committed.
There does, but I think how affirmative defenses play into that, at least on my quick read of the case law, it's just unclear. But again, that's certainly not briefed in this case, and I don't think is presented by this factual scenario where there is not a clear self-defense that would apply. I think in this scenario, we would be comfortable defending this as a conviction based purely on these facts, kind of beyond a reasonable doubt. But that's not obviously the issue that's presented to this court. I did just want to note quickly on the typo in the warrant, just to be clear, we're not conceding that it was defective. The warrant was defective as to that. We agree there's a typo, but we think the parenthetical as the carrying a pistol without a license does adequately explain what the grounds are for the warrant in this case.
Just one question on
Yes.
the standard of review.
Sure.
So the reply brief cites United States versus Castle.
Yeah.
To try to suggest that we are in some sense bound by the district court's findings rather than being able to sort of conduct an independent review.
Yeah.
Have you looked into that case? And can you explain why and when we apply that rule?
Sure. So Castle is a case where it's a Terry stop on the and so there's a motion to suppress based on that. There isn't a warrant in that case. And so the district court is making fact finding, and this court would defer to that fact finding, but would not defer to the ultimate question on probable cause. I think the Supreme Court case on Ornelas, which I think is 1996, explains that probable cause gets reviewed de novo. subsidiary fact finding gets clear air review. I think probably the more helpful case is the Glover case from this court in 2012, which is in the warrant affidavit context. That likewise says you get clear air review for fact finding and de novo review for sufficiency of the warrant. But when you have a warrant affidavit, unless there's something like a Frank's claim, in which case you would take evidence, normally you're just looking at the affidavit and seeing if there's probable cause based on that. That gets de novo review. If there are no further questions, we'd ask this court to affirm.
Thank you, counsel. Mr. Cohen, we'll give you 2 minutes for a rebuttal.
Thank you, Judge. I want to follow up on Judge Garcia's question about the standard of review. We have here egregiously erroneous findings by the district court, the U.S. District Court, which said erroneously, and I think it's undisputed, that my client, Mr. Payne, was the shooter. Okay. And I think it's important, although I don't want to focus so much on the Second Amendment aspect, that's a bit of a revealing comment, because what the district court was saying, in effect, was this was the aggressor. This was the shooter. This was not the victim of a shooting who's then reacting to the threat. And then there are other errors that are made by the district court. And so for this court, for the first time, to say, okay, we're going to review all the record here, it's not a good case to do that. I also want to address the affirmative defense thing that came out, because I think that muddles the issue. We are talking about a search warrant required by the Fourth Amendment. So we're not talking about whether the defendant could raise affirmative defenses at trial. We're talking when the self-defense term that we've been talking about is from constitutional law. It's talking about the scope of the Second Amendment right to bear arms. And so when the police see a person exercising, in this case, it happens to be the Second Amendment, but there's a lot of other constitutional rights out there, and does a description of someone exercising their constitutional rights and goes to a magistrate judge, says, Judge, give us authority to search this person's home. The answer is no. You've just laid out very troublesome constitutional issues for me. I'm not going to let you search this person's home. In addition, I see I'm over my time, but just the Second Amendment aspect is the aspect I have focused on. But there are other problems with the affidavit. One of them being that for the first time here in the government's brief, we're hearing that turns out they were searching for the misdemeanor carrying a pistol, not the felony carrying a pistol. Now, as it happens for Second Amendment purposes, and it's important for me to be clear about this, that doesn't matter. Wren has said your right to a firearm and carry a firearm extends not just to your home, but outside your home for self-defense purposes. So, but still, don't we need a district judge to make a finding? Oh yeah, this was clearly this kind of violation that the Superior Court judge was asked to issue a search warrant for. Thank you, Judge. Thank you, Your Honors.
Thank you, counsel. Thank you to both counsel. We'll take this case under submission. Mr. Cohen, you were appointed to represent the appellant in this matter, and the court thanks you for your assistance.
Case number 25-5148. National Council of Nonprofits et al. Versus Office of Management and Budget, and Russell T. Vaught in his official capacity as Director, Office of Management and Budget, appellants. Mr. Springer for the appellants, Ms. Morton for the appellees.
Good morning, counsel. Mr. Springer, please proceed when you're ready.
Good morning, Your Honors, and may it please the court. Brian Springer on behalf of the federal government. Plaintiffs in this case challenged an interim measure that was designed to address the period of transition from one presidential administration to another. The specific memo at issue was rescinded over a year ago, and we're now at a much later time in this presidency. There would be no conceivable reason to take a materially similar action at this much later time. Indeed, plaintiffs' merits arguments in the case depended on the specific features of the rescinded memo and the specific explanation that appeared in that memo. Plaintiffs' claims are moot, and they certainly cannot support the preliminary injunction that was entered by the district court. I'm happy to start with the discussion of mootness, which I think, is dispositive here and is the one that the court should reach. As our brief explained, the challenge action here was the OMB memo. I think plaintiffs make that clear in their complaint at JA 22. And that specific action has, been rescinded as well. We've had the passage of time and, final decisions have been made about a lot of the money that, we're talking about as the presidency has sort of, continued. The whole point of this memo was just to sort of take a first pass and do an initial, to have kind of a full review of the money that was going out the door, including, grants that had gone to plaintiffs and others in the prior administration. And when the new administration came in with different priorities, wanted to take a look at the money that was going out the door and to the extent that it could move money around, make a decision about whether to do so.
What about the district court findings that even after the memo was purportedly rescinded, there were still some funding that was frozen that appeared to be attributable to the memo?
Sure. I think the district court was sort of focused on the wrong question, because the question is about, what was challenged in the case and what the controversy is that's presented and whether that controversy had, a likelihood of recurring. We fully admit that, there were still the executive orders that were in place that said to pause funding in certain circumstances and that the agencies were pausing funding pursuant to those executive orders. But I think the question, particularly again, plaintiffs' merits arguments, when they're talking about the merits, they are very, very focused on the OMB memo and the specifics of the OMB memo,
Well,
exactly.
Maybe I'm misunderstanding, but I thought that the district court found that there were funding freezes that were still in place after this OMB memo was rescinded that could not be linked to executive orders or other actions and appeared to be where the OMB memo appeared to be the cause or motivating factor, notwithstanding its purported rescission. Am I wrong? The district court didn't make such a finding?
Your Honor, I think it is right that the district court did say that there were funding freezes that were continuing, although I think, again, part of the basis.
That finding was clear error?
Your Honor, we're not saying that it's clear error that the district court said that there were funding freezes that continued. I think that is, a legitimate thing that the district court found. And in fact, there were such funding freezes going on. But again,
based on that finding, found that this really wasn't rescinded. The government was claiming that it was rescinded, but it's not really rescinded. And so that's why I'm going to go ahead and adjudicate this and whether there should be a preliminary injunction. Was that finding clear error?
A couple of responses to that. I think, first of all, the question that the district court should have asked is whether or not it was likely that the memo was going to be reinstated. And I think that is kind of where the district court instead was focusing on what was actually happening. I also think that—
Why isn't it relevant whether the memo was actually really rescinded?
Your Honor,
it can't be moot. You don't get out of the gates on a mootness argument if the memo really hasn't been rescinded.
Your Honor, I think there's no dispute that the memo was rescinded. Of course, the district court thought, that there were still funding freezes that were going on, although those could be attributed to the executive orders that were still in place and remained in place that agencies were required to follow to the extent that they could under the law. I guess I would also just emphasize that now we are at a much later stage in the case. Many things have sort of transpired in the interim. I think that underscores that at least now, if not not at the time that the district court ruled this case is moot. You know, I mean, I think the only reason that we're here now is that the district court, instead of just saying, I'm enjoining OMB from applying this memo, which, I think would have been pointless because it had been rescinded, but, wouldn't have had a big practical impact. Instead, what the district court did is it went beyond that and included relief that said, even if OMB, could give a fuller explanation or change the timeframes here, or, it did sort of a more robust consideration of reliance interest, that it's still possible that that sort of action would be blocked. And I think that is what.
Is that why the government, like I've been wondering, why does the government care right now? Because if the memo is rescinded, and suppose the preliminary injunction just barred the implementation of the memo as the district court construed the memo. Because you have another argument, which is that there was a misconstruction of the memo and it's actually narrower in scope than was assumed. But let's just take as a given that the district court construed the memo as the maximalist, in a maximalist way. And then the district court enjoins actions based on that memo. You don't care, right?
I think if all the district court had done is said, you can't apply this memo, we may well not be here. I don't think that would have had a big impact.
What is the extra that is concerning you?
Sure. I mean, I think in particular, if you look at what the injunction says, it says that you can't sort of reinstate the unilateral, non-individualized directives. And I think that has led to some confusion about what OMB is allowed to do, particularly because, as I mentioned, the district court's analysis really focused on the specifics of the OMB memo. I think the problem that the district court identified was it said that the OMB memo wasn't sufficiently explained, that it provided kind of too short of a time frame, that it, didn't adequately consider reliance interests.
That's incomplete, right? Every time you focus on the specific facts and circumstances, that is about the arbitrary and capricious claim. And you might have a very good argument for those reasons that the arbitrary and capricious claim is moot. The contrary to law claim is different. It's simply OMB does not have independent authority to freeze a substantial amount of federal funding. And why isn't the way to think about this case, the mootness question, whether we have received assurances that OMB is not likely to attempt that again?
Sure. I mean, a couple of responses to that. I mean, I think, first of all, the district court's analysis on the contrary to law claim also depended on the specifics of what OMB did here. I mean, again, the district court emphasized that this was, in its view, a freeze of all funding kind of on a moment's notice and without sufficient notice. But again, I mean, I think for all the reasons that, I've discussed this morning, there's still no reason to believe that these plaintiffs would be subject to the same action again in the future, which is the question that is being asked when we're talking about, at least the voluntary cessation doctrine.
So if OMB attempts to freeze a substantial amount of federal funding, it seems highly likely these plaintiffs will be affected again. And if you take more time and give more notice, the arbitrary and capricious claim would be different. But the contrary to law claim in the complaint is OMB's statutory authority does not allow it to unilaterally terminate all federal financial assistance programs across the entire government. So I think what we would have expected to see is a declaration saying, that's not what we did, but even if you think we did, OMB will not try to do that again. And we haven't received that kind of assurance.
I mean, I think you have received that kind of, I think the prospect that OMB at this point, again, the whole point of this endeavor was, as we were transitioning from one presidential administration to another, there was an attempt to sort of look at all the funding that was going out the door. I think the likelihood, even as sort of the description that you just gave, the idea that OMB is going to unilaterally attempt to freeze all funds, which again is plaintiff's characterization. But even if you accept that characterization, the likelihood that that's going to happen again is not high. And so there was no reason for the district court to sort of reach that issue and enter this preliminary injunction.
Another way of asking, which seems relevant, is assume the district court was right about the facts, that OMB issued sort of unilaterally a broad federal funding freeze. Does the government believe OMB has statutory authority to do that?
Jenna, I mean, we haven't sort of addressed that issue because we don't
Right.
think that is what the OMB memo did here. But again, I mean, that is the way that plaintiffs are talking about this controversy, and I think the way the district court thought about this. And so that is not something that's likely to recur again, which is the question that's being asked when we ask the mootness question.
Right. So I'm thinking about the FBI Fiker case. I'm not sure I'm pronouncing it correctly, but the government basically came in and said, based on what we know now, we're not going to relist him for the things we know about today. And there's not really a good reason we can think of. And I think the court unanimously said that doesn't satisfy the burden on voluntary cessation. There needs to be an affirmative representation that the government will not subject these plaintiffs to this type of action again.
You know, I mean, I guess that's not how I don't read the case to say that the government has to make such an affirmative representation. I think it is a very contextual analysis. And I think here, the context of how this dispute arose and the context particularly of the OMB memo shows that it's unlikely that this is going to recur. I mean, there's just no conceivable reason for OMB to do this again because it was all tied to the specifics of changing from one administration to another. And, you know, plaintiffs had gotten grants in the prior administration that the new administration with its new priorities wanted to look at and reassess.
So I guess you haven't talked about the Q&A clarification that came about the day after the memo was issued. So why don't you talk about that more? I guess I'm not understanding, because if the way that the case has been interpreted so far, including by the district court, is the maximalist interpretation of the memo, and the government itself said within hours that that's actually not the way to interpret it, then does that bear on the likelihood that the maximalist memo, actually that kind of action would be undertaken again?
Senator, I mean, I suppose it, you know, it may show that it's unlikely that, you know, because again, that's not what OMB thought happened in the first instance. And I think what OMB saw is that agencies may in some instances have been implementing things too broadly. So it stepped in very quickly and said, no, what, you know, we meant by the memo was that it covers these things and doesn't cover these things, just to sort of clarify that and make sure agencies going forward were implementing it correctly. So I think that could bolster the case to show that, you know, the government never thought that this was how broad this was going to be. But even if you sort of, again, take plaintiffs at their own terms and say that's the controversy that they think they put before the district court and that the district court ruled on, that makes it particularly unlikely that it's going to recur.
And I mean, it seems to me that bears on the line of questioning that Judge Wilkins had too, if I'm understanding correctly, which is that even if there was funding that was frozen, based on what you think is an erroneous interpretation of the initial memo, what the challengers obviously think is the only plausible interpretation of the initial memo, then that's just going to take a little time to unwind. It's just the natural course of things. And then the clarification comes along the next day, and it didn't have the immediate effect because there were interpretations in effect that were going to take some time to unwind. I take it that, would your position be any different if the clarification came along and said, not that this is what we meant all along, that's the only fair way to read the initial memo? What if it said, we recognize there's a lot of confusion, we didn't word that well. We actually never meant for it to be interpreted in the way that it is. We just want to clarify that what we mean to freeze is those programs and activities and funding assistance that's tethered, that intersects with the executive orders. We never meant to have even a temporary freeze of anything beyond that. To the extent that we erroneously indicated that because of the capacious language in the initial memo, we regret that. Would your position be any different if that had been what the clarification had said?
So, I guess I'm not sure that it would be any different. I think it, you know, I mean, I think we have sort of the form of it where this memo was issued and OMB very quickly said, what we meant by the memo was this. We see maybe agencies out in the world are, you know, kind of implementing this more broadly than we thought they would. So just want to clarify that's what we meant by the scope of this memo. And of course, plaintiffs could challenge, you know, to the extent that there was sort of a final agency action and a right challenge in the appropriate forum, they could challenge on. I mean, again, they'd have to sort of check all the boxes that are necessary to get one of those challenges in a court. But if there was some specific funding stream or their, money was frozen and they thought that either under a statute or regulation or something that they were supposed to be paid, they could challenge sort of that follow-on, decision. But here, what they're challenging is the OMB memo.
The initial memo.
That's correct, Your Honor.
You briefly said, I think, and then just ran past it. You don't join in that argument, right?
That's correct, Your Honor, not appeal.
We have a few questions about the merits theory, which in some way tie back to mootness. So I just want to understand the position you're taking. At times in the brief, it seems to be the assertion that OMB really didn't do anything independently at all. All it did was implement things the president had already ordered. At other times, I know you don't agree with the maximalist version. It seems you're saying OMB has authority to go a little bit further than the president did. Which of those is it?
So, Your Honor, I think the right way to think about what happened here was that we had these executive orders that came out, very early in the administration that pointed to specific types of fund, announced certain policies of the United States and pointed to certain types of funding that should be paused if they were implicated. And I think what OMB did in its memo is it clarified that instruction to agencies to say, here's what you should be doing and here's the way that this should work, and tried to sort of get OMB involved because OMB, is sort of making sure both that the agencies are properly implementing the administration's policies and getting involved in, let us know if you have questions so we can help you with these budgetary matters.
So it sounds like you're saying it's the first thing, that OMB did not direct the freeze of anything that the president had not already directed be frozen.
Your Honor, I think the right way to think about what OMB did is that it said that, the same as the way the executive orders described it, if we're talking about funding that's discretionary, then, to the extent that it may implicate one of the president's executive orders that you should, and you have the authority under law to do so, then you should freeze that funding so we can have a more fuller review and discussion about whether to move the funding.
That's what I thought the delta is that for the OMB memo, the executive orders didn't talk about a temporary freeze, did they?
Your Honor, the executive orders did talk about pausing funding.
But was it for a time certain while things were explored?
Your Honor, it wasn't for a time certain. The OMB memo did clarify sort of some of the timeframes. Please get back to us within this time and give us this information so that we can have sort of a fuller discussion.
I thought your understanding of what the OMB memo intended to do, as elucidated by the clarification, the next day Q&A clarification, is that for a temporary period, something that may implicate the executive orders ought to be frozen. And then we'll take some time to figure out whether it in fact does implicate the executive orders in a way that's problematic. And we'll make a more informed decision at that point, whether the freeze is going to continue or not. But am I misunderstanding?
No, I think that's right, Your Honor. OMB elaborated on what the process should be so that what agencies were doing was sort of making a first pass and saying, here are things that we both think that we have the authority to pause and that we think may implicate these orders. So then there could be a fuller discussion to decide, what the final disposition of those funds should be.
And it may not end up being frozen, even if for a temporary period it was, because the clarification said we might even be able to figure this out in a day.
Right. That's correct, Your Honor. And, there have been now many final decisions that have been made, some of which have been, let's terminate this funding and move it to something else. Some have been to continue to allow the funding to, go out the door.
So can I ask why was the initial memo, if it's construed from the government's perspective in the way that the clarification said it ought to be construed, why rescind it?
Your Honor, I think the reason was just that, the OMB had seen that there was confusion about how it should be implemented, even with the guidance. And so it just kind of to make sure that agencies understood they should continue to follow what the executive orders suggested, but not to kind of keep the specifics of the OMB memo in place. I think that's why it was sort of to try to eliminate some of the confusion that had gone out into the world.
Sure, my colleagues don't.
Just seems we're glossing over variability in what the EOs said, right? There's sort of two dimensions of what happened that are being disputed. What is the scope of what was frozen and who directed that it be frozen? So assume that there are, which I think is rather clear, there's some category of funding that the president said review, but didn't say pause. And OMB came in and said, to facilitate the review, immediately pause. Right? Is that your understanding? And are you defending that that is lawful? OMB is adding a temporary freeze to facilitate what the president ordered.
Sure. I mean, I think what the president ordered in the identified a pause of funding to do the review. And so OMB was just sort of implementing how that should actually play out in practice.
If the facts were what I said, does OMB have authority to do it?
Your Honor, I mean, I don't want to get out ahead of what the agency can do. I mean, I guess I think here what we're talking about, and again, I mean, this is something that happened a long time ago. And I think our main objection to what the district court did is it didn't just say you can't apply this OMB memo that I have, found these specific problems with. Instead, it sort of went beyond that and made it so that there's this open-ended injunction that allows the plaintiffs to come into court and, have fights about whether something in the future is too similar to that.
And can you just tell me concretely, like give me the concrete circumstance in which the way the injunction is articulated would raise a concern vis-a-vis something that OMB would like to do?
So, I mean, I don't want to specifically say that, this would be prohibited by the injunction, but you could imagine if OMB wanted to issue another memo and instead of the time frame that it had in the initial memo, it did a time frame of 1 month and it included more explanation. It also said very clearly, here's our kind of preliminary consideration of reliance interests and agencies. You should take into account reliance interests. I mean, I think that at least the district court's injunction, it's possible that it would cover that and block OMB from doing that if it was sort of the same thing, but just with fuller explanation, even though the only, the real problem that the district court identified was just one about the specifics of this memo. And I just think that's contrary to, how APA review usually works, where you're, directing the relief against, you're saying you can't apply this agency memo or this agency action to the plaintiffs.
And just to be clear, and because this can bear on many aspects of the case, the hypothetical that you just laid out, you're talking about a memo that would involve a temporary freeze for funding that's tethered, that might be bound up in executive orders. You're not talking about an across the board freeze of all federal financial assistance.
I mean, yes, Your Honor. My understanding is that OMB never had the, under the memo, never had the intention to sort of go beyond that. But I just think there's some, especially because what the district court said was unilateral, non-individualized directives. It's unclear what we're talking about when we say individualized. Does that mean it has to be at the grant level? Does that mean it can be agency specific or sub-agency specific? I think there's just or program specific. I just think there's a lot of questions that are left unanswered. And that is what has created some problems for, the government, and the reason that, we're here to say that this injunction should be vacated.
So let's suppose we were to agree with you that aspect of the preliminary injunction was too broad or should be vacated at this point, as far as under what circumstances the government could reinstate a similar memo or guidance. And we agree with your argument that, this memo has been rescinded, and basically if the only thing, the only remedy that was properly kind of entered by the district court was essentially stop the effectuation of this memo, that's moot. I guess your position would be that if we were to agree with you and say that the case is moot at this point, if there were ever a situation in the future where one of these plaintiffs had their funding frozen and they believed that it was attributed to this memo because it wasn't really completely rescinded. In fact, even though the administration says it was, your position would be that they don't need a preliminary injunction because they could get whatever relief. If they could establish that their funding was frozen in the future based on the memo that was rescinded, that's essentially either contempt or a laydown case of arbitrary and capriciousness, so they don't really need an injunction for that. And so there's really no point in a preliminary injunction going forward at this point. Is that your position?
Sure. Yeah. I mean, to answer, just maybe to summarize what you said, I mean, I think our position is that, particularly at the time that the district court entered this preliminary injunction, it went beyond what it should do, and it was overbroad in the respects that we've discussed. And then I think as to the piece that, of the injunction that may kind of look more like traditional APA relief in saying that you can't apply this memo to these plaintiffs, because the memo's been rescinded and we're at a very different, time in the presidency, and the memo was tied to an early stage of the presidency, there's just no need to have that anymore, particularly given that there's no, semblance that OMB is going to reissue a memo like this, and really has no reason to at this point.
Has there been, when was the last time the government sought from the district court to reconsider the preliminary injunction or to vacate it?
Your Honor, I think there was I think after the preliminary injunction was entered, there was some question and fighting about how broadly it extended, whether it extended beyond or could extend beyond open awards. Since then, the government has appealed. And so now that the case is on appeal, I mean, I think, our view is that we can't ask the district court to vacate the injunction that's on appeal. But we think both at the time that the district court entered the injunction, but particularly now, this controversy has become moot, and so the injunction should be vacated.
Garcia, you had a question? No. Okay. If my colleagues don't have any additional questions at this point, we'll give you a little time for rebuttal.
Thank you.
Morton.
Good morning, Your Honors, and may it please the court. Jessica Morton for the nonprofit plaintiff appellees. I'd like to start with the proper construction of the OMB memo and move on to mootness and scope of relief. The OMB memo M2513 is perfectly clear. It is susceptible to only one reasonable construction, and the Q&A document that the government issued belatedly does not and cannot undermine that one reasonable construction.
So I guess I'm not understanding that construct for the following reason, that when you say it cannot, because they're just two memos. So one memo comes along at time one, and a second memo comes along several hours later. If the second memo says what it says, it can undo the first memo because it's just another memo. It's just telling the world there was a first memo out there. And and you're going to resist a little bit the way I'm going to spin this out, but just bear with me for a second. The first memo causing a lot of confusion. There's people who are writing stuff in the press. There's a lot of consternation about this. We realize that. Let's just clarify this a little bit more. We're going to let you know that what we really mean by this is it's only a temporary freeze for that line of funding that's implicated in the executive orders. That's all we mean. At that point, is there any doubt that the first memo kind of doesn't even matter at that point, because the second memo is telling you what the first memo means. So the fact that the first memo might have been construed in a particular way, and you might be right that that's the best understanding of it. Let's just say I give you that. That's the best understanding of it. The second memo comes along and just says, yeah, our bad. But really what we mean is this. At that point, why isn't that just the operative understanding going forward?
Three responses, Your Honor. So first, had the government really thought we made a mistake, everyone is confused, what they could have done instead of issuing the Q&A is simply rescind memo M2513 and issued a new memo that says we're replacing it with this new memo that outlays what we really meant, instead of adding this Q&A gloss. And they didn't choose to do that.
But second, why? Well, finish the first two. Finish the next two.
Sure, Your Honor. So you also, as a matter of logic, the Q&A read really just doesn't make sense because the entire point of the original memo is that OMB is ordering a pause so that the agencies can then determine in the interim, is the word they use, during the pause, what actually falls within the executive orders. And so the pause is to facilitate that determination. And if you're only pausing what is already in the executive orders, it skips that step in the order of operations. That's really not possible to operationalize in the way that this is actually working here. I think, Jay.
And the third one is?
I think this is really analogous to our deference, Your Honor. We know from Kaiser that you only defer to an agency interpretation.
So that again, I understand all these 3 points. I do and they bear on the best understanding of the first memo when it was issued. But our deference, for example, we're talking about a regulation and then an interpretation that comes along, not a second regulation. Here, it's just 2 memos. And so even if that's the best understanding of the first memo, the one that you outlined, and I'll just give you that. And it may be that the second memo, you might be right, that boy, does it even make sense to have a temporary freeze if the scope is similar to the underlying thing anyway? That may be right too, but that's just what the second memo did. It just did. And so even if the second memo kind of doesn't make a lot of sense in terms of its scope, and I think there's arguments that it might, but even if it didn't, it is just what the government says we meant to do all along. Suppose the second memo was issued 15 minutes after the first one.
Well, Your Honor, sorry, were you finished?
I think I am. But would we still be saying the same? Or actually, change it. Suppose the second memo were just an attachment to the first one.
Well, Your Honor, I would respectfully push back on the idea of this being a second memo. It's titled a Q&A. It seems to me clearly giving an interpretation of that first memo rather than being a second command. The first is a clear directive. It uses the word must. It's
right. I think I understand all that, but I don't understand why it matters that it's a Q&A as opposed to a memo. I guess my only point is that as far as the legal significance of the 2 instruments, neither one of them is on a different plane than the other one. They're both just guidances. They both just it's an internal executive branch document. The one says, here's what I need you to do, all you agencies. And then the second one says, actually, here's what I need you to do. Suppose that the second one even just says, the first one, we totally sent the wrong signal. I don't even know what we were thinking. That was just really, really misleading. What we really mean is this. At that point, isn't there, it's not like the second one can't cancel the first one. Of course it can, because it's just the OMB telling executive branch agencies what to do. And they're just saying, actually, here's what we want you to do.
Respectfully, Your Honor, I think the first memo is a clear directive, and the second really is an explanation of OMB's later post hoc rationalization, having seen the consternation that this caused. And I'm
sorry to keep belaboring it, but I don't understand why that matters, because isn't the second one pretty clear?
I don't think it is, Your Honor.
On whether the funding that needs to be stopped is only the funding that's bound up with the executive orders. How could it be more clear? Is this a freeze on all federal financial assistance? No. The pause does not apply across the board. At least on that respect, it seems clear.
Your Honor, I understand completely what you're saying there, but I do think the order of operations that the original memo puts forward still pervades the Q&A. J62, the second page of it, it says, the guidance is establishing the process for the agencies to work with OMB to determine quickly whether it's inconsistent with the EOs. A pause could be as short as a day. And this still, implies to me that the pause is for the purpose, as in memo 13, of determining whether or not it actually does fall within the EOs or not. And so I just don't see a way to operationalize the Q&A that is not consistent with memo 13. And that's how all the agencies really understood it. At J23, there's an email from NSF that was sent after the Q&A saying it's pausing everything because of the OMB memo.
Then what would have happened? And by the way, none of this is to suggest that this was at all clear in the time that this was happening. I think there was a lot of understandable confusion, and probably this is not, the best way to conduct business with agencies that one is supervising at OMB, probably given the consternation and confusion that was caused. So I'm not suggesting that. But in terms of the operative effect of this, what if this was in the original memo? This was just an attachment to the original memo. It's a weird way to do it. I grant you that.
I think, I didn't interrupt you, I'm sorry.
But wouldn't that just be, everybody would know that the original memo isn't a freeze across the board because the attachment says that. So we have to go forward on an understanding. There may be still some confusion about its exact parameters. That happens all the time in internal executive branch stuff. That's when you get on the phone and talk to OMB, as apparently this document indicates it already happened in some instances. And wouldn't that be pretty clear that it's not an across the board freeze?
I don't think so, Your Honor. I think it's helpful to be clear that what we're talking about is not sort of edge questions, whether something is near an EO or not, but the district court found, this is at J332, that all of the evidence the plaintiffs put forward was about catastrophic freezes that were totally untethered to the executive orders. At the preliminary relief hearing, the district court asked the government to explain which executive order was responsible for all the pauses, and the government was not able to do that because, as the district court properly understood, the issue here are these freezes happening across the board, separate from the executive orders.
I think there's a lot to that, and I think probably it was the case that a lot of people understandably read the initial memo and feared that it meant an across-the-board freeze. And I guess that's why I keep coming back to the Q&A the next day that just said, and it was regrettable, all the confusion that was caused and has real world consequences. So I don't mean to minimize that in the least. But as of the second day, when the clarification, the Q&A issues, that understanding just seems to me that it's not on the table because OMB is just telling everybody that's not the way to construe it.
I don't think the OMB was saying that clearly. I think we can know that because, it's not just a fear. This is actual harm that happened because the agencies universally implemented the freeze in the way that was properly understood from the original memo. And in fact, did not unfreeze funding until after the court had entered its TRO. Some of our clients didn't get their funds until February 4th or February 6th or even February 7th. And so there's no evidence that I'm aware of in the record that any agency understood the Q&A to be operative. They were still acting at the behest of the must directive in M2513. And so, what we're really challenging is what happened. And there's certainly possible an alternative universe where OMB had immediately recognized a mistake and clarified it. They could have issued a memo that rescinded M2513 and made clear the scope that they wanted to. They could have followed up with the agencies. When the court entered its preliminary relief, it said, send a notice to the agencies and make clear that they understand they should no longer be freezing funds at the behest of memo M2513. And OMB could have certainly done that on its own if they had truly wanted the narrower Q&A version, but they didn't take any of those steps. And
so do you think the case would be different if instead of saying, is this a freeze on all federal financial system? No, the pause does not apply across the board. If the OMB had said, to the extent the memo has been construed in that fashion, it's rescinded.
Had it been rescinded and then truly rescinded, and there was not a suggestion of voluntary cessation as we have here, I think it would be different, Your Honor, had OMB done something much more concrete than the Q&A.
Can I ask you, please?
On mootness, if based on the government's representation that this memo, they've not just a representation, they've issued a directive saying that it's been rescinded. And then they come to our court and say the case is moot because the memo is rescinded. The government at this point, if we were to declare the case moot, if they were to ever act essentially pursuant to this memo to freeze funding, they'd be subject to contempt, subject to all sorts of sanctions. God help them if I were the district court and that were to happen. So why do you need a preliminary injunction?
Well, Your Honor, a couple of points on that. So just to be clear at the outset, the preliminary relief we have here really is the only thing that has meaningfully changed since we were litigating a year ago, and that is what is keeping this harm at bay. And we have, significant evidence in the record. This is at JA 289, 293, and 296 that our clients and their members will be in imminent irreparable harm the minute that a freeze were to kick back in. We saw in the record, this is around JA 231, that even one day of a freeze caused some of our clients' members to have to stop.
That assumes that they would do it again. And what I'm saying to you is, why would we presume that they would do that, a freeze again based on this memo, when they have represented to the district court and our court that the memo has been rescinded? And the minute that that happened, I would think that the district judge would have whatever officials responsible for any freeze to be in her courtroom and tell them to bring their toothbrushes, because there may not be going back home after the hearing if that's what had happened. So why do you need an injunction?
Well, just to clarify this standard, Your Honor, I heard the government, I think, say that we haven't shown a likelihood this might recur. That's really not the standard here. The government bears the burden on mootness. And in the voluntary cessation area, which we have here, it's a formidable burden under FCRA, and they have to show that it's absolutely clear it will not recur. And I would submit that the government has not made that showing. They have not submitted any evidence at all. As Judge Garcia pointed out, in FCRA, the government submitted a declaration, and that still was not sufficient in FCRA. But they haven't even done that here. I heard some statements from counsel that there's no.
Can I just ask, what concretely, if we declare the case as moot, what are you concerned will recur?
Well, Your Honor, if the court were to think the case is moot, then we would very much request that the court not vacate the judgment below under Munsingware and Bancorp. I think that would be inappropriate for equitable reasons, particularly given the voluntary nature of the mootness here. And so if in particular the court were to vacate the preliminary relief below given mootness, then I think that would eliminate all of the options that Judge Wilkins was talking about, the district court to continue enforcing it.
Okay, but right. So what is the concern? Is the concern that OMB will again impose a broad-based freeze on all federal funding as you construed the OMB memo?
It is, Your Honor. OMB has certainly not shied away from continued interest in funding freezes. We have some examples at pages 46 and 47 of our brief that lay out some statements from the director about potential freezes they're considering. And the salient point is that we have no evidence that the government won't do this again. It's really their burden to show that they won't recur, and they've put nothing in the record to meet that burden.
So I think, I'm not saying I find this persuasive, but what they have said is what this case involved, what the district court's judgment addresses is a broad-based freeze on all federal funding. Here are the reasons you shouldn't think that will recur. We never meant to do that. Two is, today, we're not arguing we can do that. And they said today, there's no conceivable reason that we would do that again in the future. And it's not obvious to me that a freeze of a more specific program would be the kind of thing, which are examples of what you have cited in your brief, would be the kind of thing that would keep the question that's framed by this case alive, which is very much tethered to the breadth of the funding freeze. So why shouldn't we be asking, what is the reason to think OMB will attempt to freeze all or nearly all federal funds again?
Well, Your Honor, I don't think it's surprising that OMB has not threatened to take an action that they are currently barred from taking by this order. But I do think that, the government has said in court they don't plan to do this, but that's not really the standard under FECA. That's not the standard. They have to put forward some evidence. And, if the court truly believed that this case had been moot, they could have done what they did in National Endowment for Democracy, the United States, which is case number 255361, where the government asked this court to hold their appeal in abeyance and remand the district court so they could put forward a motion to dismiss for mootness. They could have asked the district for that here, and they haven't done so. They haven't put forward any evidence that this is absolutely clear it will not recur. And
So one facet of that I think bolsters the hypo, at least that Judge Garcia laid out, which is that we never meant to do this in the first place, is the clarification.
the Q&A, you mean?
Yeah, the Q&A. Yeah, because there was an understandable interpretation by hypothesis that there was an across-the-board freeze, and then the interpretation comes along the next day. And there's a little bit of confusion about exactly when it happened. I mean, I think the lawsuit was filed at around noon. Then sounds like you all got the Q&A at around 1:30. So who knows exactly what came first? I'm not going to try to deconstruct that. And I don't know that anybody knows that. But they were kind of roughly, a lot of stuff was happening at around the same time, totally understandable given the rampant confusion. But that's a fact about the world, is that the OMB did issue that clarification that conveys that this was never meant to be an across-the-board freeze to begin with. That seems like it could bear on whether there's going to be an effort to do an across-the-board freeze again. That's kind of proof positive that it was never meant to be one to begin with.
Well, Your Honor, the district court judge considered those arguments in district court and weighed them with the evidence that all of the agencies had in fact continued a broad freeze, and determined that first, that the conduct had not, the conduct as we understand Memo 2513 had not ceased, and that to the extent it was voluntary cessation. Those factual findings deserve deference to the clear error standard.
But I don't know that the district court, first of all, they didn't talk about it in terms of mootness. And second of all, I think it may well be true. And the district court was operating under really extenuating circumstances and completely understandably handled the case in the manner it did, especially at the initial stages when nobody had a real handle on what was going on. But in terms of the effect of the Q&A, it could be that because there was a misinterpretation, and maybe it was the executive order supplementing that, that led to an across-the-board freeze or a too broad a freeze in some quarters, it takes a little while for that to unwind. So that, and then it did ultimately. That just seems kind of maybe in the natural course of things. It's very unfortunate that happened, that there was an overage, and probably based on the way that the memo was articulated in the first place. But would that be the reason? Couldn't that be a reason that it took it? I mean, are you suggesting that actually the clarification was always meant to be a ruse, and that actually the government didn't mean what it said, and what it really meant was that there should be an across-the-board freeze, and that every agency should continue acting as if there's across-the-board freeze, even though we've sent a Q&A that says there's not?
Your Honor, the fact that the memo is in my view and in the view of all the agencies administering it quite clear, I think is probative of what the original intent was. And to the extent that the government really believed that the Q&A is all they had ever intended to do, they could have simply put a declaration in court to that effect, explaining this. They could have asked to remand and made that factual finding more clear.
I mean, of course, they rescinded the memo, the first memo this next day anyway. And we're talking about things that happened 2 days in succession. So at that point, I think they're thinking whatever we meant by the Q&A, that's been superseded by the fact that the underlying memo is rescinded.
Oh, of course, Your Honor. And then, the freeze continued after that. There was evidence that the press secretary put forward that it was not rescinded at all. And so in the wake of all of that.
And what do you think? Is it your view then that either the rescission or the clarification were not real?
I think that the rescission itself was at best immaterial and clearly not abided by. And I think the district court said at worst an attempt to manipulate the court's jurisdiction. And I think the district court was well within its discretion to understand.
But apart from the court's jurisdiction, I just mean in the real world, do you think that the rescission actually wasn't a rescission, that the government, that OMB rescinded it, but they were really, there was a wink, wink, nod, nod to other agencies that, yes, we've rescinded it, but you should still continue to freeze the funds. Or I'm honestly, I'm not trying to engage in some kind of gross characterization. I'm just wondering what you really think the effect of the rescission, and for that matter, the Q&A was.
Well, I think, Your Honor, that the press secretary's tweet that it was not a rescission with not in all caps was clear that it was not a rescission, and that the agency is continuing to freeze after that tweet and after the purported rescission made clear that the agencies understood it that way as well. And had OMB thought that's wrong, it really was a true rescission, there's more that OMB could have done. For example, sending a notice to the agencies directing them quite clearly to release any funds that they had frozen under their interpretation of Memo 2513, and they did not do so.
So what's the bottom line then on the rescission? Do you think it actually was rescinded or not?
I don't think, I think it was purported to be rescinded, but I do not think it was a valid rescission. And I think that the voluntary cessation doctrine fully applies here.
But that would mean that you think if the PI goes away, then the original memo would just sort of immediately spring back to life. But now a year on, that's certainly not what would happen, right? There would need to be some more affirmative action from OMB to reinstate it.
I don't know whether that's the case, Your Honor, because after the purported rescission, the agencies continue to implement those freezes in a broad categorical way.
What's the latest evidence? Like how far after? I know there was evidence of that for 48 hours, several days, and
February. I'm sorry, Your Honor.
But it was all from February.
So there's several. So there's the EPA sent an email the day after the purported rescission, specifically referencing Memo M2513. This is at JA76. We have evidence that there were still freezes as of January 30th and 31st. And then some of our clients' members only got their funds on February 4th, 6th, and 7th. The last one is at JA309.
So, yeah, go ahead.
I was just trying to explore whether it seems like after a week or two, nobody was relying on the OMB memo anymore. There's no evidence of that. Obviously, we have a TRO and then a PI, so it's hard to sort it out. But
well, Your Honor.
Go ahead.
The TRO was entered on February 3rd, I believe, and so it's my understanding that all the evidence we had through January 31st, that the freeze was continuing. And we saw the freeze start to thaw after the TRO, and the funds coming in on the 4th, 5th, and 6th and 7th was in response to the TRO itself and not in response to purported rescission.
Maybe I misunderstood your position on mootness, but I thought your entire brief, the reason you think the case is not moot is because of voluntary cessation, because of the voluntary cessation doctrine, that the government hasn't met its burden to show that it wouldn't redo it. But I guess it sounds like what you're saying now is there may never been a cessation to begin with.
Both of those, Your Honor. So I think there never was a cessation at all, and that to the extent there was, the voluntary cessation doctrine would apply.
So your position is that the rescission, like we shouldn't we shouldn't take the rescission as a given. It wasn't even a rescission. It was not. What was it? It was just a.
I think under Laidlaw, the district court made a factual finding that it had not, in fact, been rescinded, which deserves deference under the clear error standard. And I'm certainly in no way asking, the court to make a finding of bad faith on anyone's part, but I do think that the district court's finding that it had not, in fact, ceased, or that to the extent that you take the rescission for what it's worth, that it was the voluntary cessation doctrine applies, both deserve deference here as alternative options.
And can I just ask one last question about the tweet, the press secretary's tweet, which is the government's interpretation of that is that it's actually not contrary to the rescission, because what it was saying is the OMB memo has been rescinded, but there's still whatever funding freeze remains in effect by virtue of the executive orders. So it's consistent actually with the government's understanding, because the OMB memo was rescinded. that doesn't mean there's no longer any funding freeze anywhere, because the executive orders themselves called for funding freezes in certain respects. And that's what the tweet was about, is that doesn't mean there's no longer any funding freeze. The funding freeze still is still in effect by virtue of whatever the executive orders did. And you think that interpretation, why do you think that interpretation can't be the way to interpret the two?
Well, Your Honor, I think it's at least equally and more plausible to interpret it as the district court did, and the district court in making these findings, given a plausible interpretation, deserves deference. And I think, 2 points on the tweet. So first, not to parse it too closely, but it is called the federal funding freeze, which is quite different from separate funding freezes per the EOs. And the reference to executive orders is really consistent with how the original memo works, because, it is, as I understand, I think as OMB put forward in the original memo, really created to permit time for the agencies to determine what falls under these various executive orders. And so it's a way to implement those orders. And so I think the district court was quite right to understand that as consistent with the district court's reading of memo M2513.
Did the district court make a finding that the memo wasn't really rescinded, or did the district court make a finding that it was rescinded, but that there were some agencies that, were slow to comply with the rescission, or slow to kind of get the memo, so to speak, that it had been rescinded?
I don't have the exact language at the podium, Your Honor, but my recollection is that the district court concluded that it was, that the purported rescission was at best sort of a non-entity, and at worst an attempt to manipulate the court's jurisdiction. I don't think those are the precise words that she used, but I don't believe the district court made any finding that this was just slow to turn back on, but really, understood properly that all of the agencies were behaving in the same way consistent with M2513. And the district court cited, I believe, the Commerce case and said, I don't have to be naive whenever all the agencies are undertaking something in the same exact way at the same exact time, that is really probative of what is really happening here.
I think, to be fair, weren't all of those statements, all of that was taken as evidence that the OMB memo was intended to be broad, not that it was a distinct issue whether it was rescinded. That's why Judge Ali Khan was looking to agencies' reaction in the first instance to bolster the idea that this was a freeze on all federal financial assistance.
She certainly was, Your Honor, and I don't have perfect recollection whether she, re-upped those findings in the mootness section of the analysis as well. But the district court certainly did find the voluntary cessation doctrine applied here.
So I have just one last set of questions. It's about how you understand the injunction.
Yes, Your Honor.
So I'll admit that when I read, you may not reinstate under a different name the unilateral non-individualized directives in OMB Memorandum M2513. I actually find that incredibly clear. She's just written an opinion that says, I read the OMB memo to freeze all federal funds. So this is ordering them not to freeze all federal funds again.
That's right, Your Honor.
Okay, so, but when you then think about mootness, the best indication, I think I asked this question earlier. What's the best indication that the government is going to try again to freeze all federal funds, which is all this case is about? And I think they haven't affirmatively disclaimed an intent to do that. And OMB, as recently as in the past few months, has done more targeted freezes. Is there any other reason to think they will again freeze all federal funding?
I think given that they bear the burden to show that, the fact they've put forward no evidence whatsoever is itself probative, Your Honor. Just to amplify, not only Judge Garcia, but also the First Circuit has reviewed that language and in the face of similar vagueness objections from the government, and also found it to be clear. I think footnote 7 of the district court's order further amplifies the clarity of what, or the opinion of what the court is ordering. And just to clarify one of Judge Wilkins' questions earlier, the government, to my knowledge, did not ask for any clarification in the district court. The government is correct that there was some briefing about the scope of the order. That was at the part of the plaintiffs. We were asking for an understanding of whether of what open awards meant, but the government did not actually ask to clarify at any point in the last year.
But I think your answers to me mean if tomorrow OMB announces, given it some more thought, we are instituting a new 30-day pause of all federal funding tied specifically and explicitly without any ambiguity to Green New Deal and DEI projects. You'd have to say that's not even covered by this injunction, right?
Well, Your Honor, I think that that would be a different case, depending on how it's worded. If it is as narrowly tailored as you suggested, I do think that the district court statutory authority arguments would be similar in that new case, or district court statutory authority conclusions would be similar in that new case.
It's just, I don't know if you can help me with this, but there's a very bizarre artificiality to this case, which is all anyone disagrees about on the merits is, did OMB order the freeze of some funds or all funds? If it's all funds, everyone agrees, or no one's arguing otherwise, that it was unlawful. And if it is just some funds, you haven't advanced any argument that it was unlawful. And so the whole thing turns on the interpretation of this memo that's been rescinded.
Your Honor, respectfully, I don't think it is an artificial case because we know what actually happened, and the government has...
You could think it's moot while also thinking the district court and the plaintiffs did all exactly the right things. But that a year later, after all the dust has settled, it's hard to see what maintaining this injunction does to protect your clients if it's only against a new broad federal funding freeze. It seems like it would be, there's just no reason to think they'll do that.
Well, Your Honor, they haven't put forward any evidence that they aren't going to, and they're trying very hard in this through this appeal to make sure they have the ability to do so again. I think, in West Virginia, the EPA, the court noted that having, vigorously defended legitimacy of their approach was probative in that understanding of mootness, and that the passage of time itself is also not independently sufficient. I think in FICRA, they cite parents involved as declining to dismiss a case as moot 5 years after an alleged voluntary cessation. And so, in light of the fact that the government is still contending through this appeal that it has the right to do this, and that they haven't put forward.
That's the oddity that I was trying to get at. And it is not obvious that it leads to it being moot. But when you say this, you mean a broad federal funding freeze, and they are not arguing they can do that. That's the oddity. And maybe you're right that it's not moot because they have not given affirmative representations they won't do it again. But they're not, this is not the Clean Power Plan, and they're, defending the legality of generation shifting. They're saying we never meant to do generation shifting in the first place. Why are we here? So, sorry, that's not a question.
No, I mean, as Your Honor points out, if we all have the same understanding of what the preliminary relief actually prohibits, and the government does not have any intention of undertaking those actions, it's hard for me to understand why we're here at this appeal, and also why they haven't taken the very simple steps of putting forward a declaration or other evidence that they do not, in fact, intend to redo another federal funding freeze.
Thank you.
So help me understand, if we were to say that this case is moot based on the finding that the preliminary injunction only enjoins a unilateral, non-individualized directive from OMB to freeze funds, and an understanding that the government has no intention of government represents that that was not what they intended to do and in the first place, but putting that aside, they've given no intention that they are going to do that again. And based on that, we find this moot. If the government were to then do another unilateral funding freeze, at that point, judicial estoppel, I think, would kick in with respect to whether or not the preliminary injunction should just be reinstated that was vacated. So I guess I'm just trying to understand why you still need the preliminary injunction, because one way or the other, them asking us to moot the case, they're either going to have to not do what they say that they're not going to do, or the minute they do it, essentially, what would happen would be a motion to reinstate the injunction based on their actions, and they'd be in the same world of trouble as they would have been in had they violated the injunction and it had stayed in effect. Like what more do you get from, or why isn't that the way that would play out?
Well, Your Honor, I think, this conversation really goes to who bears the burden of potential wrongdoing. And under the scenario that Your Honor laid out, if the government were to succeed here and then go and do the thing they've said they don't want to do, then we would have to rush into court again. And during that time, we've shown in this case that even a very, very brief imminent freeze was causing irreparable harm to our clients.
You mean you'd have to rush into court if we just affirm the injunction? I mean, if they were to take some action in the future to freeze funds, I mean, it's not self-executing. You would have to execute for your clients by going in and seeking contempt or whatever.
I do think there's a difference, Your Honor, between the government being, under a court order and simply, having to worry about explaining themselves to district court if the court order had been vacated. But again, it's not our burden to show we still need this injunction. The law is very clear. It's the government's burden to show that it has become moot, and they have not put forward any evidence that enables it to meet that burden.
Well, there's mootness, and then there's also equitable relief, and preliminary injunctions are not meant to last forever. Right. And at some point, a preliminary injunction, outlives its usefulness. And so even if it doesn't technically meet the mootness standard for their voluntary cessation, it would seem to me that as a court of appeals, one option we have is to just say, look, there's really no need for this anymore. And equitable relief, you balance all of these things. And as we balance all of these things, maybe the balance now is different than it was, in February of last year, a year ago.
With respect, Your Honor, 2 points there. So first of all, nothing has changed other than the passage of time. The Q&A, the purported rescission, they all had happened before the district court issued its order. I think that goes to my second point, which is that, the balancing is really in the discretion of the district court judge. And so if there's a question of whether it has become moot now, I think the most appropriate course is to remand to the district court to make those factual findings and do that balancing in the first instance. But regardless, if the court does find it's moot, we really do think that there's no need to vacate under Munsingware.
I'm sure colleagues don't have additional questions. Thank you, counsel.
Thank you.
Mr. Springer, we'll give you 3 minutes for a rebuttal.
Thank you, Your Honors. Excuse me. I think the discussion with the other side and the focus on the specifics of what the memo said or didn't say and what happened a year ago just underscores that this controversy, has become moot and that the district court went beyond resolving the particular controversy that was before it. So I think that's an important point that sort of comes out in the discussion. And I would just say, I think, look, we think that this injunction should be vacated, but at an absolute minimum, the court should clarify it the way that Judge Garcia explained the injunction, to apply just to across the board funding freezes. I think that is something that is very clearly moot, but that sort of clarification, I think, would have gone a long way if it had been, something that the district court had done. Our real worry here is that OMB obviously has significant statutory authority in this area, and the way that the injunction is phrased, there's some fear of it interfering with things that, OMB is permissibly able to do, particularly because, again, the district court's analysis was really focused on the particulars of this memo, the specific contours of the memo, and the specific explanation that appeared in the memo. So, I think that's really the fear that was generated here. So we do think that the injunction should be vacated, but at a minimum, it should be clarified.
So that last piece I don't understand. The district court's opinion was very much about this memo and how it viewed this memo. And it's very clear about how it viewed the memo. It viewed it as a freeze on all federal funding. So you've represented that there's not been any consideration of anything like that. So I don't understand what the fear is. If you,
Your Honor, I think there's just language in the injunction in particular. Particularly discussion, I think as we discussed earlier about non-individualized directives, it's not just saying, again, the usual relief to enter in a case like this is one that says you can't apply, this memo or this agency action to the plaintiffs. And what the district court said was you can't reinstate under a different name the unilateral non-individualized directives. I think there are questions about what it means to do non-individualized directives. I do think, again, we do think that this injunction should be vacated, particularly because the case has become moot. But at an absolute minimum, the court could clarify that, that is just meant to prohibit across the board freezes, which again, I think the other side has admitted is sort of what the controversy was here about. And that's the thing that's also not very likely to recur.
I'm not saying you had to do it, but you could have gone to the district court and asked for that clarification.
Your Honor, I think we, look, we were sort of engaged in a bunch of different, we have other cases that are going on and we wanted to make sure that we got the right clarification. I think at the time, things were very fast moving and there were decisions that were being made about what to do. And so there was a decision made that we should appeal just because we were worried about the particulars. And obviously we're also now at a very different stage than we were, even 6 or 7 months ago, where there have been sort of final decisions that have been made that have kind of decreased the practical effects of, the case.
but you're not able to say OMB has no intention of initiating another broad federal funding freeze.
Your Honor,
You can only say you can't think of a good reason they would.
Your Honor, I don't see any reason that OMB would do that, particularly not for the lifespan of this case, which is, and we're up here on a preliminary injunction. Obviously don't want to get ahead of what a future agency can do. And we just want to be sure that this isn't interfering with, permissible things that OMB is allowed to do pursuant to its, clear statutory authority here.
Okay. Thank you, counsel.
Thank you, Your
Thank you to
Honors.
both counsel. We'll take this case under submission.
Case number 25-5367. SZ DJI Technology Co Limited and SZ DJI Technology Co Limited appellants versus United States Department of Defense et al. Mr. Schaefer for the appellants, Ms. McDowell for the appellants.
Good morning, counsel. Mr. Schaefer, please proceed when you're ready.
Good morning, Chief Judge Srinivasan. Good morning, Your Honors. Your Honors, the stakes in this appeal are high for my client DJI, but they're even higher and broader given that core cherished principles of administrative law hang in the balance. In our respectful view, this court cannot possibly affirm without compromising the principles and precedents that this court has long and faithfully superintended. Because essential explanation and evidence from the agency are both missing on this record, this court has ample grounds for vacating the instant listing of DJI. And I'd emphasize, Your Honor, that to its credit, the district court made things streamlined and simple for this court. It expressly rejected most of the premises for DoD listing DJI as it did. So all that remains is a slender, frail thread of reasoning. My modest submission to Your Honors is simply that the statutory terms, together with this court's settled precedent, dispose of that sole persisting thread on which the validity of DoD's listing depends. So let me start, if I may, Your Honors, with the statutory question of assistance. This is, Your Honors, 1260H, letter D, numeral 2, letter A. So here, Your Honors, to identify a, quote, military-civil fusion contributor, the agency is meant to look to whether an entity is, quote, knowingly receiving assistance, close quote, through the Chinese military planning apparatus in any given year. Against that statutory backdrop, the evidentiary gaps are manifest. And I'd note at the outset, Your Honor, that 1,600 plus companies have received the same award in various years without being listed by DoD. I'll return to that point later, Your Honors, but you can see that in App 649. DoD's record establishes that there are 16 other plus companies.
Sorry to pause you. I just want to make sure that the clock is running.
Oh, good point. Good point, Your Honor.
We won't dock you, but good.
Thank you. So putting that observation aside for the moment, the latest evidence of DJI receiving recognition as a, quote, National Enterprise Technology Center, NETC, Your Honor, that's from 2021 at the latest. You can find that in the app 275. That, Your Honors, is a far cry from DJI currently receiving assistance as is necessary for these listings. And note, Your Honors, that Congress specifically intends the listing to be made annually and to be revisited annually. So to say that a 2021 recognition carries forward to 2025 is to really undo that congressional intent that DoD's.
Why would we think that a recognition by the Chinese government is itself time limited?
Well,
If we thought that the record establishes that at one time it came with benefits like tax breaks, the explicit purpose of which is to support a company, why would, and we don't know whether they're time limited or not, isn't it reasonable to think that they would be ongoing?
Your Honor, I think Congress thought the opposite. I think Congress thought that this was to be made explicitly based on the latest and best information available, and that you can have delistings, the agency shall delist. And so if it were that any recognition at any time meant that you are perpetually understood to be knowingly receiving benefits, you wouldn't have that operation of the statute. But also, Judge Garcia, I mean, it's DoD's cherry pick record, but it does tell you 1,600 plus companies have received this award over time. It's an award, Your Honors. It's like the Grammys. It's like Chambers. It's something that is done every year. And Judge Garcia, respectfully, there is nothing in the record that says the extent to which companies on whom the award is bestowed get those tax benefits.
Even past awards have ongoing benefits. If you talk about a Pulitzer Prize winning author, yes, they won the Pulitzer Prize 8 years ago, but they're a Pulitzer Prize winning author forever, and that carries something, a Nobel Prize winning physicist. So it's conceivable, just because it's a past award doesn't necessarily mean it doesn't have current effects. It doesn't necessarily mean that it does, but it doesn't necessarily mean that it doesn't. And on this one, with the unclassified part of the the instrument that we're reviewing, it does say that DJI benefits from the NETC qualification through tax breaks, free cash subsidies, and financial support, and benefits in the present sense. And is that, do you disagree with that?
Chief Judge,
You don't-
I
you don't
do.
benefit. So is it true that there's no enhanced eligibility for a tax subsidy now by virtue of having gotten the NETC recognition in the past?
Maybe my quarrel is a legal one, Chief Judge, but I don't think, if I am theoretically eligible for a tax break, I think there is a leap to say, and I am benefiting from the tax break.
So that I understand the legal point, but I just want to know as a factual matter, is there a dispute before us on whether, because of a past recognition as an NETC, there is a current eligibility for a tax subsidy that otherwise wouldn't be there but for the NETC designation?
Chief Judge Srinivasan, there is a factual blank on that. Keep in mind, I didn't get to make any bit of this record. This is DOD's record. We had no chance to make any submissions to it whatsoever. We haven't been heard by anyone. But there's nothing, and I stand on this, there is nothing in DOD's record that says the 2021 award has any import, even eligibility import for DJI. And I think
the document says benefits through tax breaks. And so benefits is present sense.
I'm
It's not
sorry.
benefited. It says benefits.
Are you
So
referring to the DOD report or to the article that is cited in that?
the report?
Okay.
The report itself on Appendix 276,
Yeah, and-
classified bullet point says benefits. And I'm just, can you make a representation? Is there a current benefit in terms of eligibility for a tax break that otherwise wouldn't exist but for the NETC recognition?
2 points. I will answer Your Honor's question, but let me start, please, with the fact that this is a substantial evidence challenge. So our point, what you're reading from the report does not have substantial evidence to support it. All right, put that aside.
Yeah.
And that's what Your Honors will be upholding. If you say this is good enough as to DJI for any of these 1,600 plus companies, the fact that they ever receive the award means they are knowingly receiving benefits. We would submit that follows. What I can tell Your Honor is my best understanding is that DJI is not knowingly receiving benefits from the Chinese military planning apparatus through this award or otherwise. I offer that
I
to
guess-
Your Honor, but I don't have that.
Let me add a little
in
bit
the
to that. And
record.
if you can't answer it, I understand that because I understand your legal point about substantial evidence. But let me just ask on the factual question. And if you can't answer it, you can't answer it. But it's one thing to say we're not currently receiving financial benefits if that means we're not receiving a tax break. But what I'm asking about is eligibility to get a tax break that otherwise wouldn't be there because of the NETC designation.
I think I understand what Your Honors say, but I want to be precise about this. My understanding is that the 2021 award does not result in any current eligibility for a tax break, not even a theoretical. So there's that temporal issue. But then Your Honor's asking, am I disputing that the record establishes that the award recipient, DJI or anyone else, is theoretically eligible for benefits? We are not disputing that. I think that is established by the record. But what I think DOD needs to do is connect it.
What is established by the record?
That a recipient of the award, by virtue of receiving the award, has some theoretical eligibility for benefits, tax benefits or other benefits, just like
Presently has eligibility.
Not from the 2021 award, not from the 2000. I believe that these awards are given on an annual or biannual basis.
I see. So your understanding is that if you get if you get a recognition in 2021, you're eligible for tax breaks in that year. But then even the eligibility for tax breaks cuts off at the end of 2021. You need to get.
That is my understanding. You have to re-up. That is my understanding. Okay. And these are regular awards. They're not awards that are given in perpetuity. They are given and they are revisited. And there's also nothing in the record.
Company gets it over and over.
It could be the same company or it could not get the.
Do you know that the same company has gotten it over and over?
I think that there have been some recurring recipients, but not all are recurring as recipients. And I don't have.
I take the point that this is not in the record, so I'm not slighting that point, but I just was curious about your general understanding by way of context.
And let me also note, there's nothing in the record about what's required to apply for the award. What level of agency is required for that? What percentage of award recipients actually qualify for any of the benefits and avail themselves of those benefits. What percentage of the award recipients are in fact companies that are associated with China as opposed to companies like Volkswagen and Nokia that have also received it? So, and I'd note, Chief Judge Srinivasan, I think that the theory that DOD pivots to in front of this court is separate and distinct. The award, as I understand the way they treat the award now, the award itself is the benefit. That's what they're offering to Your Honor.
Just procedurally, in the district court, did you say, look, this award in 2021 doesn't come with any tax breaks? This report conclusion is erroneous and not supported by substantial evidence. And here is a declaration or some other evidence that shows that DJI isn't getting any tax break.
Judge Wilkins, we had what we had submitted to DOD previously as to why DJI was not deserving of the listing. But in a case that involves...
Did any of that say what I just said?
No, because it had not been relied upon by DOD for prior listings that DJI had received the NETC award. That was new. And then...
Okay, but once you saw the document that's, the report from, I guess it's 2023, that's in the JA and the language at 276, did you, in the district court, say there's no substantial evidence to support this finding that DJI benefits from the NETC qualification because that's not how these tax breaks work? And here's a declaration.
Judge Wilkins, I thought myself constrained. It was an APA challenge. DOD was perfectly clear that the administrative record had closed and that the challenge would need to be decided within the four corners of that record. And so there was no opportunity for us to do that. But what I did argue to the district court is what I'm respectfully arguing to Your Honors, that you look at the record, the same record that I'm held to, DOD is held to, and you just will not find that substantial evidence is our submission. And I think DOD recognizes that, which is why they offer a different theory to Your Honors, which is one where the award itself is the benefits. And for the same reasons we'll talk about later, Your Honors, the Chenery Doctrine, I don't think that DOD here can rely on a rationale that's different from what Your Honors will see in the report. We're talking.
I guess just to put a ribbon on this, I mean, yes, it's an administrative case and the court is bound by the administrative records, but there's lots of instances where an agency makes an assertion and it's in the administrative record and then there's a finding. The agency doesn't always have to show all their work. There can be just a conclusion that's made. And in those circumstances where a regulated party believes that that conclusion isn't really supported by substantial evidence, there is a mechanism for party to say to the court, that's not the case.
Well, Judge Wilkins, here's my friendly amendment to Your Honor's premise. I mean, I've had those cases. I welcome those cases. They're usually cases where we have an ALJ or we have an agency that's taking submissions from the adversely affected party, and we have the chance to make our record that way. And then when I'm before the court, I can rely upon that administrative record and explain what the agency failed to account for. I mean, this is the rare APA case where I'm coming to you at the mercy of DOD's cherry pick record. And I still submit to Your Honors in earnest that you will not find in DOD's record substantial evidence supporting its conclusion. That's not a very demanding standard. I would recognize it's not a very demanding one, but it's one that has some bite and it's not been met here.
Just one more question on the procedural issue. My understanding is that in 2023, you did submit a delisting petition that's in our JA at 1195. Is there a reason, maybe you thought it was not going to do anything? Is there a reason you didn't try that this time?
We did, Judge Garcia, to be clear, we've sought reconsideration since April. So we have had pending with DOD submission seeking reconsideration. There's no timeline on that. There's no obligation for DOD to do anything with it. So we are seeking reconsideration into now 2026. We just don't have any response to that. And that reconsideration submission is not part of the administrative
It's not
record.
part of our record.
Because it had closed. And this was after we were,
In those, have you made the factual representations you're making today? Obviously, you would about what this NETC recognition is and eligibility for benefits and so forth.
Judge Garcia, what we have said is DJI is not knowingly receiving anything from the Chinese military planning apparatus. That is our submission. I'm not in a position to make representations to Your Honor about DJI status relative to this award. I simply submit to Your Honors that the record is what the record is. And if this record suffices for DJI, it suffices for any company that happens to have been listed as for receiving the NETC award in 2021. And that argument is what it is, Your Honors. That's a substantial evidence argument. We also have our argument about the absence of reasoned explanation as to another separate essential statutory requirement that needs to be satisfied. This is the one requiring that there be an explanation for why DJI contributes to the quote Chinese defense industrial base, close quote. This is under 1260.
As to that part of it, is it your understanding that it's common ground here that that part of the statute is an additional element?
Yes, that is common ground, and Judge Friedman was very clear about that. I don't think DOD disputes that for this line of analysis, which is what was upheld.
Because my understanding is that in other cases that may not be so clear. That it may be that that's redundant of the first part that we've been talking about is a military civil fusion contributor.
Thank you for the clarification. I will leave it to my friends to offer their statutory construction. I think at least in a portion of their brief, they do seem to suggest, just as you're saying, Your Honor, that these are they're coextensive inquiries, and to say that DJI was a military civil fusion contributor who received benefits establishes that it's now flowing the opposite way, that it's contributing to the Chinese defense industrial base. That is a statutory argument that they've advanced to the court. I think, Your Honor, it really does, it guts the congressional intent to have these be separate and distinct inquiries. It also takes away Judge Friedman's express rationale. He was very clear, Chief Judge Srinivasan, that he found comfort from the fact that it would not suffice, solely for DOD to establish that DJI had received the NETC award. He said they would separately need to show that a company is contributing to the Chinese defense industrial base. And that's also how Congress structured the statute. There's a definition, the definitional portion of military civil fusion contributor, that's a defined term. And it says there that it suffices for the company to have received. But then in the earlier portion of the statute, when it talks about the Chinese defense industrial base, it just uses, this term is a standalone term. It would basically collapse two separate statutory inquiries to say that they fold together, and satisfying one suffices for the other. I don't think that that's a coherent.
Itemized in the report.
It is, Your Honor. So I think contemporaneously DOD analyzed it that way. They've argued it that way. That's how the district court analyzed it in this case and also the SI case. So I leave it to my friends for the other side if they're going to offer a different argument. I don't think that that's plausible or available to them at this point. So assuming that this needs to be separately satisfied, and I don't think that's a controversial proposition, I think it is equally undisputed, Your Honors, that DOD's entire purported rationale, I mean, every syllable of it, apart from the heading, is classified such that neither DJI nor the district court have reviewed it at all. That, Your Honors, decides the case in our respectful submission in our current posture. There's just no path to affirmance consistent with Chenery and its progeny. I point this court to its decision in Burwell, but there are many of them that say.
But at JA 273, the summary findings, the report, the unclassified report, in explaining the summary findings, says that DJI provides commercial services, manufacturing, producing, or exporting through the development, manufacturing, and sale of drone and camera technology And so based on the foregoing that the Department of Defense makes this determination and so can't we look to the summary findings and elsewhere in the report to see, I guess, as the district court did, whether this finding about contributing to the Chinese military, whatever the proper terminology is, that there's substantial evidence for that finding?
I'm sorry to disagree with Your Honor's premise, but I don't think the district court thought it was finding in DOD's report, contemporaneous report, the explanation for why DJI was deemed to be contributing to the Chinese defense industrial base. The district court, I think, was very clear that he saw it clear enough from DOD's briefing and was inclined to credit that. That's my understanding of what the district court did. And what Your Honor's quoting from the report, yes, the DOD did observe that DJI makes commercial and recreational drones. I would agree it does that. But to say that it necessarily follows simply from that it is contributing to the Chinese defense industrial base would have astonishing and I think unacceptable implications for a whole stripe of companies, including those who make drones, but also those who make automobiles.
But there's also a finding at that same page, JA273, that DJI is indirectly owned or beneficially owned by Chinese state-owned entities.
That was rejected by Judge Friedman. He specifically, that's a separate path potentially to deeming a company to be a Chinese military company. And you can also find in the decision where Judge Friedman found that that was not established as a matter of fact and as a matter of law and as a matter of due process. And DOD has not cross-appealed on that. So I don't think that that's an available rationale for differentiating DJI from all sorts of other companies that make all sorts of other commercial and recreational products that could theoretically.
Rejecting a finding that they are indirectly owned or controlled is not the same as rejecting a finding that they work with and might be benefiting the Chinese.
I've read that report carefully many times, Judge Wilkins. I don't see in the unclassified record anything that says DJI is working with the China or the Chinese military, let alone doing that to develop drones in a way that is part of civil military fusion. I don't find that in the report. Now, I don't know what I'm not seeing. I don't know that. But the reason I don't know that is because we're talking about, as Chief Judge Srinivasan and I were discussing, there is a specific portion of the report that reflects this determination under this heading. And all I have is the heading. Everything else is blacked out. So I don't know what's there in the district court.
Let's suppose we review the classified portion and let's suppose we agree with you that the unclassified portion, there's not substantial evidence to meet the standard. But once we review the classified portion, we believe that there is.
I'd like to see if I can dissuade you from doing that, maybe at a later stage of the argument, but I'll accept Your Honor's hypothetical for I would ask Your Honor to review that with the same, judicial scrutiny that applies to any portion of the record. You won't have had the benefit of my arguments at that point. You won't have had adversarial process on it. But I do submit that you have from DOD a definition elsewhere of what it means to be contributing to a defense industrial base. It means you have to be able to meet military requirements. We've cited that definition in our brief. There's nothing different from DOD here. You have DOD acknowledging these are commercial and recreational drones that DJI makes. And I do have an unclassified record of evidence supposedly surrounding the findings that are made by DOD. And those portions of the record, I'll quote them to Your Honors, established.
I'd like to get to the answer to my question rather than pushing it off to the.
Okay.
Why shouldn't we look at the classified record? And if we think the classified record definitively answers the question and supports the designation, we affirm. Why shouldn't we do that?
I think Your Honor should be just as loath to do that in this case as you were in the TikTok case and as the Supreme Court was, where it disavowed any reliance upon the classified record, and Justice Gorsuch concurred after this court had taken that approach. I think that there are obviously core precepts that are part of judicial process that this court cares deeply about. And you see it in cases like Green, you see it in Microsoft, you see it in all sorts of cases where this court has said is a matter of judicial process. You do not want to have us be completely barred from having any access to evidence on which this court would rely. And of course, the district court, which is meant to be doing this work in the first instance, hasn't done any of this. I think you would want Judge Friedman's determination. We had a motion to compel the classified record to our security cleared counsel, Mr. Nitza, who was prepared to look at whatever could be shared. That was never decided because the district court effectively deemed that submission moot because he wasn't looking at or relying upon the classified evidence at all. And you also have in this case, you have demonstration that when you have completely untested evidence, then you do have mistakes.
You have a statute that says that the court can look at this ex parte, right? You didn't have such a statute in the TikTok and other cases, right?
Well, in TikTok, you had a congressional statute that didn't speak to the process, but you had Congress's determination.
Here, Congress dictated the process. And, you know, we have cases like Rawls where, you know, a company is barred from an acquisition. And we said in Rawls that due process entitles you to no more than the unclassified record. So to the extent that the president makes a determination that you cannot acquire this U.S. company for national security reasons, the only thing you're entitled to know and try to respond and defend and change the president's mind is based on the unclassified record.
You did say that, Judge Wilkins, and as you were vacating in that case because, or in remanding because there had not been access to the unclassified evidence. So I don't think you had to reach the bottom line holding that you would have to reach here as a matter of, I think, first impression. And I acknowledge you do have congressional prescription that says there can be ex parte in-camera submissions. I don't think that tells you what the constitutional floor is. That's not up to Congress. That's up to this court. I don't think that tells you how the court manages its own business, which is under Article 3 in the separation of powers. I don't think you should be deferring to Congress about unduly deferring to Congress about how your honors are conducting your review of the district court at this point. But I would also emphasize, Judge Wilkins, every syllable of this has been redacted, every syllable. And we know that there's unclassified evidence that's being cited in support. And we're offering security cleared counsel who could, you know, under whatever strictures, have a glimpse of a summary of what DOD is doing with the relevant evidence. And one other point, Your Honors, of course, Your Honors' precedent on this will be critically important to a host of regulated parties. I mean, it's not just DJI who will care a lot about Your Honors' decision, it's other companies. And they should know, is DOD saying that anyone who makes a commercial or recreational drone by virtue of that is contributing to the Chinese military industrial base? Is it because there are specific showings as to these, what's being done to convert these products on the battlefield? Is it because of specific alleged ties to China that DJI is being differentiated? Or is it, as DOD seems to suggest in their brief, the mere fact that someone makes a product that could hypothetically be converted for some use on a battlefield means DOD can say that they've satisfied this requirement? To say that this court has relied on the classified evidence alone, I think would be really problematic as a matter of precedent too.
Counsel, as a doctrinal matter, is the due process clause the exclusive source of your right to review the classified information?
It's a great question, Judge Garcia. I don't have a definitive answer to that. I don't think it's the sole exclusive source. And I would note, I think due process operates differently once we are in court and have a right to be in court and we're obtaining judicial review as compared to what we will talk about with respect to pre-deprivation administrative process.
Yeah, I think you can see where the question is going, right? Is it bound up in this question of whether you have a liberty interest at stake? And if just so that we understand the position, whether, you know, if you read Rawls and all these other cases, they are analyzing this as a due process matter, not sort of some inherent matter of judicial process.
I think I do know where the question's going. So let me answer it this way, Judge Garcia. even if you disagree with me as to whether DJI was entitled to pre-deprivation process as a matter of due process, which it did not receive, even if you disagree with me there, you're not done with me for purposes of deciding, is there a due process or other problem with reviewing the classified record? Because
Well, if, I'm not saying I think this, but if we concluded that there is no liberty interest or property interest protected by the due process clause at stake in these proceedings, then it does seem like the source for your right of access to classified information is gone, right?
I respectfully disagree with that, Your Honor. And the reason why.
And what is the separate,
Yeah.
that's my
Yeah.
simple question is what other source other than the due process clause?
I don't have chapter and verse to cite you here, but I'm giving you my best answer. I think it does come from Article 3 and how judicial process operates. I think it is by virtue of the fact, I don't think that you could disregard due process for this purpose any more than you could disregard, and I mean, this is just a hypothetical, Your Honors. If it turned out that a judicial decision maker in DJI's case had been bribed to reach a decision in favor of the government, that would be a due process problem, notwithstanding that DJI, before it was in court as a litigant, had not been entitled to pre-deprivation administrative process. I think that there's just a strong judicial norm that needs to be enforced as well. And US v. Microsoft, this court was talking about how disfavored ex parte communications are as conflicting with fundamental precepts of our system of justice. In Aborezk v. Reagan, the same concept was coming out, not tied to, necessarily property or liberty that had been established at the threshold prior to that proceeding. And I think that's how the Supreme Court spoke of it in Green too. I also have Third Circuit cases that I think kind of take the concept beyond the strict threshold analysis of whether pre-litigation a party had suffered a deprivation.
I appreciate all that. Can I, in interest of time, I just had a question about
Yes.
how you interpret the contribute prong, if we think it's a separate prong.
Yes.
And I take it one thing I know you don't think is enough is a company sells products through retailers that could be purchased by a military, correct?
That's correct, Your Honor, especially if the products need to be converted in order to find military use.
Yeah, so how much, we're going to walk up the chain here.
Okay.
Is it enough if you know that the Chinese military is purchasing your products?
Before we go down this.
What does it mean?
I just want to be clear about one thing, Judge Garcia.
Yeah.
What I believe is that DOD's articulation of its rationale is critically important, and it needs to be a reasoned explanation.
You may win on the Chenery ground, 100%.
All I mean to say is it's not up to me in the first instance to tell Your Honors what would need to be established. I think DOD has work to do to say, here is our principled statutory interpretation and why a company satisfies. So I think a lot to be fair to Your Honor's question, a lot depends on what DOD has said in the classified portion of this record or in some other record where they've explained what is their rationale for the listing of this company as compared to others. And now I take Your Honor's questions as I find them. I just don't want to pretend that I'm able to speak for DOD as to what might be an operative rationale.
But counsel, let's suppose you have a company that makes widgets.
Yes, Your Honor.
And and so it meets assume for the sake of the question that it meets the first standard, that it is a military civil fusion contributor. And maybe, anybody, I or anybody else could buy these widgets off of Amazon. But maybe because these widgets, the way that they work, and they're unique and they're special, they're great, that military buys them. Maybe U.S. military buys them. Maybe the Chinese military buys them as well. Is that company, does that meet the contribute to the Chinese defense industrial base?
I'm skeptical that it would, Judge Wilkins. I think DOD would have to do a lot of work to convince you that the statute goes that far.
If militaries around the world love these widgets, including the Chinese military, then why isn't that contributing to the Chinese defense industrial base?
this court had the same explanation basically in the Genis v. FDA case that we cite. There's no limit to the statutory construction at that point. And I think you would have that problem here if we mean militaries love batteries, militaries love computers, militaries love backpacks, militaries love apparel, militaries love cars. And so it becomes kind of infinitely capacious if you do it that way. But if DOD were to do it that way, I think they would need to be.
Congress can write the statute however they want to write the statute. That might be an argument that the statute is dumb, but we don't rewrite statutes for Congress.
I don't think
we interpret them and we apply it.
But that's not how I read the statute, but that also, to the best of my knowledge, is not how DOD has told you it is reading this particular statute. But I'll also say, Judge Wilkins, I think DJI is better situated than the widget company because they have a policy against military sales and military use. These are commercial and recreational drones. So what you have in the administrative record, I think, is powerful for DJI, that when there's allegedly been, use on a battlefield, the Russia-Ukraine battlefield, you've had conversion of the products. So the products are different from what DJI is making and offering. And you've had substandard use. They are not military grade. They are not fit for military use. Every single article that DOD relies upon for the DJI listing says these are inferior drones that can be shot out of the sky. They're vulnerable to jamming. They don't have the range that they should have. Everything that any military would want, let alone the Chinese military, you don't find in DJI's drones. So you have not only the policy, but those practical limitations. Now, there's something under the classification that I can't see, but everything I can see says that there has not been basis for the conclusion drawn by DOD.
Curious if you've thought about the following. Seems quite possible next week or next month, there's going to be a relisting, and that's going to, maybe it'll have the exact same explanation, but it might have a new and better explanation. How would you, if you've given thought to it, how would we think about mootness if that happens?
Well, I don't think we would be moot. I do think, as we were talking about the 2021 award for DJI, and kind of Chief Judge was talking to me about how that carries forward. I think
but it would be odd, just to put a finer point on it, would we still proceed to decide if the 2024 listing was adequately explained when there's been a new one?
Just one clarification, 2025, the 2025 listing. I think so, yes, because that would be a sign to the world. This is a name and shame regime. It's saying that DJI in 2025 was a Chinese military company. And I do think that has some persisting effect, enough for us to have a live case or controversy around that. I also think it's telling that annual listing has not yet come, Judge Garcia. I assume that DOD may welcome this court's guidance as to how it arrives at those listings. And we also have, are concerned about due process. I think it would be helpful for the sake of future listings to have a determination, even irrespective perhaps of what you do with the statutory questions, to say that there should be some pre-deprivation process or at least post-deprivation process. We've had none of that. I know that I've been up here a long time, so I would just rest on our briefing as to other points that I've not been able to cover unless your honors have other questions.
Okay, thank you.
Thank you, your honors.
Give you a little time for rebuttal. Ms. Mitchell?
Yes. Good morning, Your Honors, and may it please the court, Urja Mittal for the government. The department identified DJI as a Chinese military company under Section 1260H. As the record shows, the Chinese government, and specifically its military industrial planning apparatus, selected DJI for special recognition in light of the drone technology that DJI is developing, drone technology which can and has been used in military conflict and for military purposes. The Chinese government's recognition of DJI as an NETC entitled the company to special policy benefits and awards. We talked earlier, and you heard earlier about some of that discussion in the record at A649, which is what the department cited in its decision. I just want to kind of talk a little bit about that because we were having this conversation earlier.
Can I take you at the outset to the second question on the statutory, the application statute, which is to the Chinese defense industrial base, that part of it. So the report has a separate heading that says DJI contributes to the Chinese Defense Industrial Base. Now, let's suppose that we have a case in which there's nothing classified, so we don't even have to worry about the redactions or anything. And the case is just like this one, and it says DJI contributes to the Chinese Defense Industrial Base, and there's literally nothing after it. And then somebody says, well, wait a minute, there's just nothing here. And it gets to court. And then what happens? How can an APA challenge to that not succeed if there's literally nothing that comes after just the conclusion that DJI contributes to the Chinese Defense Industrial Base? Would you take the position that then what should happen is that the court should look around to try to figure out whether it can piece together why the agency might have concluded that DJI contributes to the Chinese Defense Industrial Base?
I think it would depend, Your Honor, on what that agency decision said. And on other parts, I think that hypothetical, as you know, is different from what we have here because there is that classified reasoning that this court would be free to rely upon.
I'm not even sure which way that cuts, because if you have classified reasoning that's blacked out, then there's just a vacuum for these. Of course, the court can look at it. The district court did not.
Right.
But it could be that what's behind the veil is just completely illogical. I'm not suggesting, and I know there's a presumption of regularity, I totally understand that. But my point is just that if it's truly behind a veil that nobody can look at, as in the hypo where it literally says nothing. What if it said, let me just do it differently. DJI contributes to the Chinese Defense Industrial Base. And then the explanation is for reasons that DOD has concluded is the case. And if somebody wants to figure out what those reasons are, well, you should scan the rest of the record.
That would be more problematic than what you have here, Your Honor, but I think it's not just like scanning the rest of the record or the administrative record to look for those reasons. The department's decision here, even if you look at the 10 to 15 page decision that you have before it, contains all of the reasons that the district court relied on, the department relied on. And I think Judge Wilkins was referencing earlier the summary in that report and sort of if I can take a step back. So just
it doesn't tell us what the reasons that DOD concluded that DJI contributes to the Chinese Defense Industrial Base.
So the summary explains that, as Judge Wilkins was explaining, that DJI produces this drone and camera technology, and there's a separate section of the department's decision that explains what it means to produce that drone and camera technology, what that drone and camera technology does, how it's sold to other militaries around the world. There are other and so that is relevant to the agency's determination, and I think it is entirely proper in this case with this decision for the court to look to that reasoning, even if it's not under that particular heading, because
no, but how does it if the fact that it's not below that heading seems like it could well matter, because suppose what's below the heading is, notwithstanding anything else that's in this report, here's our explanation of why DJI contributes to the Chinese Defense Industrial Base. Well, then we know that we shouldn't, at least for Chenery purposes, we wouldn't be looking at elsewhere in the report.
I think, Your Honor, I can't speak to what's below the heading,
Right.
But I think it would be proper to look at the department's reasoning as a whole, because what this court is looking at is the propriety of the agency's determination that DJI is a Chinese military company. That's a determination that has these different parts, whether it's either owned by or is a military civil fusion contributor, whether that contribution is to the Chinese Defense Industrial Base. And it's proper for this court to look at all of the determinations that are in that 10 to 15 page report and the record below it. I don't think there's any reason this court has to limit itself to what's beneath that heading. If that were the case, then what that would mean is that if there's some fact.
I don't think I disagree with you that a court shouldn't limit itself, because you have to take into account the explanation and context, and you have to consider it in light of the entire report. I don't disagree with you on that. I guess what seems to raise the question is there is something under the heading, but the case has been litigated on the assumption that what's under the heading doesn't matter. And that just strikes me as tough when it's an APA challenge, because what's under the heading is definitely the first thing that one would look at in the normal course. Yes, you would look at the entire report. I don't dispute that for one moment, but the idea that there is an explanation, but that explanation just shouldn't matter, whether the DOD's application of the provision should be sustained should depend on everything other than what's under that heading, just strikes me as an odd way to do APA review.
So I wouldn't say that we've taken the position that what's under the heading doesn't matter. And this court, as you will know, is free to look at that and has the record before it and has that agency decision in unredacted form. It's that it would be because it is appropriate for the court to look at the evidence in the record and in the administrative record and the other parts of the department's decision. What the district court did here was proper, which is it looked at that evidence that's in other parts of the decision and said, look, this is sufficient to uphold the department's conclusion that DJI contributes to the Chinese defense industrial base. I don't think that's disclaiming the relevance of what's under the contributions to the Chinese defense industrial base heading. That's simply, as you said earlier, looking at that context and saying that supports that conclusion. And in other words, there's like ample evidence and all of that evidence taken together is enough.
That sounds kind of like sufficiency review, which, if it's a sufficiency of the evidence case, I could see that. But for APA review, it's supposed to be trained on the actual reasons that the agency gave. And that's what makes it a little difficult to say. If you look elsewhere, you'll see that the finding can be substantiated based on all of this, because the way that the posture of the case now, it's in a vacuum to some extent, because we don't know that that's in fact what the decision rested on, what's elsewhere in the document. It might well be sufficient. And maybe we could even stipulate to that for purposes of this exchange, but it's tricky with APA review when we're supposed to be looking at the reasons in fact given.
So, and I don't mean to repeat myself, but just to kind of take a step back, this court would be free to look at that reasoning below the heading because of the standard of review here. And I think to kind of better understand what the district court did here is we don't understand it as disregarding that. What we understand the district court did is it looked at sort of two buckets of reasoning or two kinds of reasoning. First, it said, look, the nature of the drone technology, the nature of the technology we're talking about, the nature of the product we're talking about here is drone technology, which has this sort of substantial military application. And that's detailed in this report under a separate heading that discusses DJI's development of drone and camera technology. And that points to evidence in the record, I think at like around 8296, that describes the effects and the use of drone technology in military settings. And it said, look, looking at that specific, looking at the nature of this technology, the department concluded that there was a contribution to the Chinese defense industrial base.
And so the way you've laid it out, I think it's consistent with this assumption, but I just want to make sure you don't disagree with it, that we ought to operate on the assumption that the district court reached the conclusion that that this element, DJI contributes to the Chinese defense industrial base, is satisfied without looking at the explanation that was given in the report.
That is what the district court did. The district court disclaimed reliance on anything classified. So I think that I agree with Your Honor on that point.
Okay.
And I think that was proper given the nature of this report, where there are some of the evidence is repeated in the report. Some of the conclusions are overlapping as to the nature of the drone technology and its relevance to the military sphere. And so the overlapping nature of the evidence, the fact that the same evidence could be probative to different conclusions in the department's determination, made it entirely proper for the district court to look at bullet points and paragraphs that came later in the department's decision or aspects of the administrative record that were unclassified, including the articles that the district court cited to uphold the department's determination on this point. And I think we would think that's entirely proper.
So let's suppose that the area under DJI contributes to the Chinese defense industrial base. Let's suppose that's unclassified and we can see that. And it says something that is really like illogical. It says, because DJI is just a successful company that is affiliated with China, we think that in and of itself contributes to the Chinese defense industrial base, whether they made drones or whether they made batteries or widgets. And so based on that, that's what we are resting our finding. So that's what, in my hypothetical, that's what is said in that paragraph that's redacted. And let's suppose we don't think that that meets the statutory standard. Wouldn't it be a Chenery problem for us or the district court to go look elsewhere in the report and say, well, the nature of drone technology is such that, you know, there could be ample basis to say that it contributes to the DJI contributes to the Chinese defense industrial base. Wouldn't it be problematic for us to say, well, the reason that they gave doesn't cut it, but we can find another reason somewhere in the report that does? Wouldn't that be a Chenery problem?
I think that in that case, there would be certainly an arbitrary and capricious problem that would be different from the problems that doesn't exist in this case. And there might be a problem, a Chenery problem that would emerge or at least be more apparent because of the inconsistency between what that hypothetically redacted paragraph said and what the district court concluded here, looking at, let's say, what you're saying is outside that redacted paragraph.
So how does the district court know that, so if the district court doesn't look at this redacted paragraph, how does the district court know that it's not just gobbledygook behind those redactions that don't really support this? And if that's the case, then isn't there a Chenery problem to look elsewhere in the report and say, okay, that supports the finding?
Sure, I don't think we think there's a Chenery problem here in looking at other parts of the report because these parts of the report aren't sort of entirely separable as I've been explaining. They are overlapping. They're referencing similar evidence, all of it sort of compounding and sort of building on each other about the nature of DJI's drone technology that it's producing, its contributions to the Chinese defense industrial base, its ties to the Chinese government, the benefits that's receiving. And it's because of the nature of this decision. There might be other kinds of agency decisions where one subheading is entirely separate and unrelated to another subheading, but that's not the kind of subheading we have or report we have here. I think another way of thinking, another way we know that this is not that kind of a report or context, that statutory context matters. And this is not to sort of go on to a different topic, but it's a question that Srinivasan asked earlier, which is sort of about whether being a military civil fusion contributor to the Chinese defense industrial base is in fact an entirely separate analysis. We've discussed in our brief that point as a separate point of analysis because that's how the district court approached it and it's consistent with how this decision is structured by the agency. But if you look at the statute, and that's fine, and we have no objection to this court analyzing the question the same way. But if you look at the statutory language, what Congress wrote was it directed the agency to identify a military civil fusion contributor to the Chinese defense industrial base, and then it defined in a series of enumerated definitions the term military civil fusion contributor. And we, in the first part of our brief, we explain why the NETC designation and assistance received by DJI satisfies that definition. So, which would then satisfy the term military civil fusion contributor, leaving only the question of whether that contribution was to the Chinese defense industrial base. I parse these words out not to make this a complicated statutory question, but to sort of reinforce the point that these determinations are overlapping, whether an entity is a military civil fusion contributor, and then whether that contribution is to the Chinese defense industrial base. Even in the statutory language, the word contributor appears in some senses twice. And so it makes sense then to think about to read the agency decision, understanding this is all one long analysis, looking at and where all the evidence it's like fair to look at the evidence under a different heading as probative and relevant to other parts of that statutory determination. All of this evidence is going to.
That definitely seems right. And I take the point about contributor because the Venn diagrams overlap on contributor, which kind of cuts in both directions. And it seems like it may well be the case that whatever evidence supports the first part of it, the military civil fusion contributor, could also bear, maybe to a material extent, maybe to a dispositive extent, on whether it's also a contributor to the Chinese defense industrial base. But the way you've spelled it out now, I don't understand you to be taking the position that is, in fact, totally redundant, that there's nothing separate to the Chinese defense industrial base part of it.
That's right, Your Honor. And I don't mean to say it's entirely redundant.
I just
That's
wanna
why
make sure I
it's a
understood the
separate
government's position.
part of the
Okay.
brief. I just think this is another reason why it's not a Chenery problem, and it would be that another reason why it's fair for the district court and this court to look at the evidence on these other pages of the department's decision. And I'll run through it super quickly, just some of that relevant evidence in other parts of the department's decision that we've highlighted. There is obviously that section on DJI's development of drone and camera technology, that the purchase by the Ukrainian Defense Ministry of DJI drones, 27.5 million of it. There's discussion on pages 4 and 5 of the use of DJI drones by the PLA to develop additional technological inventions, discussion on page 5 of the National University of Defense Technology using DJI drones to develop and patent additional inventions. So I'm not saying you need to look or rely on all of that. I think the district court's sort of simpler reasoning more than suffices to uphold the contributions to the Chinese defense industrial base analysis, but there is plenty there that sort of is overlapping.
Can I just ask about the district court's rules seem, as I understand it, is so long as you have a product that has a substantial non-theoretical military application somewhere, that's enough. There doesn't need to be any connection to the Chinese defense industrial base under the district court's analysis. Is that correct?
The definition that the district court applied and sort of the definition that it quotes from its earlier decision in the Hisai case is similar to what Your Honor's just setting out.
Why wouldn't there have to be some kind of a nexus to the Chinese
I think you're right.
defense industrial base?
You're right, Your Honor, that there would need to be that kind of a nexus here, and we think that there is enough evidence in the department's decision of that nexus. There is evidence of substantial military application in exactly the way the district court explained in the use of these drones in warfare in the Russia-Ukraine conflict, in the obvious military application of this kind of drone technology just writ large, as set forth in the articles in the record around, I think, 296 about the use of drone technology in military settings. And then there's evidence of DJI's ties to the Chinese defense industrial base, as we've set forth in our brief, through sort of, again, what I was describing earlier, this overlapping evidence throughout the record and throughout the decision. DJI has ties to the Chinese military industrial planning apparatus. It received this special designation, was selected by Chinese military planners for this designation as an NETC. What the purpose of this entity, this Chinese government body that bestows this designation, seeks to identify companies where economic advancement and progress will help the military establishment in China. That's what the National Development Reform Commission does. It's part of the state council and bodies that do this. There's evidence of other ties to the Chinese state, as Judge Wilkins was describing earlier. I think all of that, in this case at least, provides evidence not only of a substantial military application, but that nexus to the Chinese defense industrial base. And so I think that's sufficient here. I think the specific wording of the district court's definition in Hisai that it applied here doesn't include the word Chinese as perhaps it should, as Your Honor points out, but there's ample evidence of that here. So I think you get all of it when you look at the department's reasoning here.
Thank you. Can I take you then to the other part of the statute, the overlapping but other part, military civil fusion contributor? Mm-hmm. And so there's the unclassified bullet on 276 of the appendix that says DJI benefits from the NEPC qualification through tax breaks, free cash subsidies, and financial support from state-owned capital. So are you relying on that as the receiving assistance? Or are you saying that just by virtue of the NETC designation, that's receiving assistance? Doesn't even matter that the consequence of getting the NETC qualification is that there's available, apparently, tax breaks, free cash subsidies, and financial support?
So the department's decision here relies on the benefits that the NETC qualification entitled DJI 2, which are where the citation here is to that page on 649 of the JA. I think on the question of whether the designation alone would suffice, that's not what the department has said in its decision, and it's not the reasoning that we're defending here, but I think it would suffice. Probably, it's not, the department has taken a position on that, but I think it's helpful to look at the statutory language here and in the amended statute at G3A, which is the section that contains the knowingly receiving assistance prong now. The Congress, in amending the statute, made clear that selection or designation as an enterprise associated with industrial planning or military civil fusion efforts would in fact suffice as knowingly receiving
under the amended version of the
under the
statute.
amended version of the statute. And so to the extent there's any question about whether these benefits are being received and whether the benefits are assistance and whether they're ongoing, the fact that of the designation itself is clearly exactly the kind of conduct that Congress intended to capture in this provision. It's I think useful background point,
But for purposes of the arguments before us now, you're not taking the position that the designation alone, you're not taking the position that the DOD's determination should be sustained based on the designation alone.
the department's determination need not be sustained on that basis because of the record evidence and because of the way the department arrived at this decision, because the record evidence made clear that receiving this NETC designation, being conferred with a special recognition, automatically entitles you to these cash subsidies from the central government, from provincial governments, to tax benefits, to eligibility, to other kinds of policy benefits, again, from both the central government and from other sub-central governments. That was why the department arrived at this conclusion that DJI benefits from that qualification. And so there was essentially like too much evidence here, or more evidence than just the designation.
And do you think that wouldn't matter if all of that expired at the end of the year and it had to be re-upped in order for those benefits to be sustained to the next year?
So there wasn't any, if that were the case, that would be a different case, but the record evidence here didn't say that all that expired. DJI hasn't proffered any evidence that all that expired, hadn't made any of those arguments or provided any declaration saying so in district court or in this court, in the court of its briefing.
Is there record evidence that we should take note of that says that it doesn't expire?
There's no evidence on the time frame, sort of as your honors, I think both Judge Garcia and you were pointing out earlier, there isn't evidence about sort of how long this recognition lasts. I think I'll make one kind of point that there was, to the extent any inference needed to be drawn, a lot of these kinds of policy benefits, subsidies, tax benefits, so on, that are described in this article, not just at the top where it's talking about DJI, but sort of throughout, appear to be the kinds of assistance and benefits that would have sort of long-running beneficial effects or assistance.
This is the article cited in the footnote?
This is the article cited in the footnote, sort of, that we cite in our brief for this point. There's one article, and so it would be reasonable to infer that there are ongoing benefits from this designation to the extent you're receiving sort of 5 to 15 million yuan or so forth, but there is no time frame sort of set forth in the article itself.
Make sure my colleagues don't have additional questions. Okay.
Okay, thank you.
Thank you, counsel.
We'd ask this court to affirm.
Thank you. Mr. Schaefer, we'll give you 3 minutes for rebuttal.
Thank you. Very kind, Your Honor. Let me start where you finished, just in terms of the new statute versus old statute. Judge Friedman was very clear. He was relying upon the old statute, which is what DOD had listed DJI under. That's footnote 3 of the decision that's before Your Honors. And that was because DOD had argued it that way, and they had made their rationale, as Your Honor was noting, under the prior statute. If they were operating under the new statute, then they would have had to provide a public justification for listing DJI as they did. They didn't do that when the designation was first made, so they would have that problem under the new statute. We've let go of that, Your Honors, because we've just said, okay, this is being decided under the old statute as it was by the district court. Last point, Chief Judge, this new statute doesn't speak to the question we were focused on, whether you need to have assistance apart from the award. It just says that if you receive it under a different type of award, you receive assistance through that award, that will suffice. It doesn't say that the award itself is the assistance. I think it still falls to DOD to have substantial evidence that there was actual assistance. Let me turn to the other point, though, Your Honors, about contributions to the Chinese defense industrial base. I just want to emphasize that everything under the heading is in fact blacked out. None of it was reviewed by Judge Friedman. He was very clear about that. He never went to a SCIF. He never accessed the classified record. He's never seen it so far as the record reflects. And he deemed our motion to compel the classified evidence moot simply because it played no part in his decision. So one problem, I think, Chief Judge Srinivasan, is the Chenery problem, that whatever DOD has as its operative rationale, we're all blind to that right now, unless you look at the classified evidence. But another problem you have, as DOD now through counsel tries to cobble together the rationale, you can find it in this portion of the report, you can find it in that other heading. Well, Your Honor, if unclassified portions of the record supply DOD's operative rationale, why was it all classified? Wouldn't we have been entitled under that theory of DOD's rationale to see that they're saying about DJI for this purpose, things that they've said about DJI for other separate statutory purposes? You just cannot, I think, credit this as a principled classification and also say it is replicated in other portions of the report. That is another reason why I don't think you can do what DOD's counsel is urging you to do and kind of cobble together the rationale elsewhere. And the discussions that you're having, right, with DOD are critically important. Is it, Judge Wilkins, just about widgets? Is it that's good enough if there are widgets that a military might ever purchase? Is it the fact that widgets were purchased by the Chinese military? Is it the fact that these widgets have particular military uses? We don't know. I don't know what exactly is DOD's rationale. And I think that's critically important to Your Honor's decision in this case, and also critically important to other regulated entities that are trying to understand how DOD comes to the rationale that it does. Now, last point, Your Honors, we're not demanding the impossible of DOD. All they need is some substantial evidence that connects the dots that we were talking about with respect to assistance. They have that's substantial evidence. There are just gaps in the record as we were discussing earlier. And for this purpose, contributions to the Chinese defense industrial base, if they want to bottom line it and say, here is why we're finding that, they can provide that in an unclassified way that we can review and challenge and that Your Honors can review. You don't have that in this case. You should insist upon that before you uphold a listing like this. That's our respectful submission to Your Honors.
Thank you, counsel. Thank you to both counsel. We'll take this case under submission.
The honorable court has adjourned until Tuesday, February 8th at 9:30 a.m.